Next page. Chapter 23, Winding Up of Companies, Study Notes. 23.1 Modes of Winding Up and Alternatives. 2 types of winding up, S343-1, S79-1 of the 2008 Act. Winding up by the court, compulsory, initiated by court application, usually by a creditor, insolvent company, or shareholder, solvent company. Voluntary winding up, initiated by special resolution of shareholders, S349, S81-1 of the 2008 Act. Creditors voluntary winding up, creditors conduct the process. Members voluntary winding up, conducted by shareholders, for solvent companies, S81-1 of the 2008 Act. Conversion from voluntary to court-ordered winding up, S354-1, SS79-3 and 81-1A, 2, of the 2008 Act. Can be converted on application by a creditor, a member, the master, or the company. Court may confirm prior steps taken. Alternative to winding up, business rescue. Applicable when a company is financially distressed with a prospect of rescue. Priority over winding up applications, Van Niekerk v. Saraso 321 cc, 2012, Zochk 63. Court may issue business rescue orders, S131-7 of the 2008 Act. Suspense liquidation proceedings, S131-6. Winding up order may be issued if business rescue application is dismissed, S131-4b. Compromise with creditors, S155 of the 2008 Act. Can be done even if the company is in the winding up process. _ 23.2 Winding up by court. 23.2.1 Jurisdiction of court. 1973 Act, S12-1. High court jurisdiction based on registered office or main place of business. If different locations, both courts may have jurisdiction. Payslip Investment Holdings CCBY2K Tech Limited 2001, 4, SA 781, C. 2008 Act. No specific jurisdiction clause. Preferred approach, use High Court with jurisdiction over the registered address. Sibakulu Construction, Proprietary, Limited v. Wedgwood Village Golf Country Estate, Proprietary, Limited, Nedbank Limited Intervening, 2013, 1, SA 191, WCC. Registered address definition, main office or principal place of business in South Africa, S23-3B. After liquidation, company continues to reside at former place of business for jurisdiction, PMG Motors Kyalami, Proprietary, Limited v. First Rand Bank Limited, Westbank Division 2015, 2, SA 634, SCA, 640. No ruling on jurisdiction before liquidation. Best to file application based on registered office. _ Legislative Framework for Winding Up. Companies Act 71 of 2008, SS 79-81, governs solvent companies. Companies Act 61 of 1973, Chapter 14, SS 337-426, still applies to insolvent companies under transitional provisions, SCH 5, Item 9(1) of the 2008 Act. Certain provisions, SS 343, 344, 346, 348-353, apply only where necessary to implement SS 79-83 of the 2008 Act, SCH 5, Item 9(2). Insolvency Act provisions. S 339, insolvency laws apply to companies unable to pay debts, unless provided otherwise. Other applicable sections. S 340, voidable dispositions, S 342, application of assets to costs and claims, S 366, proof of claims, S 412, meetings, S 416, interrogations, S 417, inquiries. Certain sections apply only to insolvent companies, for example, SS 340, 416, 417. _ Key case law on jurisdiction and winding up. Melville v. Hussain and another 2012, 1, SA 233, ECP, 1973 Act applies to liquidation of companies under the 2008 Act. Trusts are not companies and cannot be liquidated under Chapter 14 of the 1973 Act. HABH Holdings, Proprietary, Limited and others v. Steinhoff International Holdings NV and others, 2021. Court has jurisdiction to wind up external companies under S 337 of the 1973 Act. Richter v. Absa Bank Limited 2015, 5, SA 57, SCA, Liquidation proceedings include both voluntary and compulsory processes post-final winding up order. Underscore. This summary provides a structured and detailed overview of the winding up process, the jurisdictional issues, alternative remedies, and relevant legislation and case law. Let me know if you need further elaboration on specific sections. Next page. Winding up of a company by court. Legislative provisions. Insolvent companies, Section 344 of the 1973 Companies Act. Solvent companies, Section 81(1) of the 2008 Companies Act. Key principle: winding up depends on commercial solvency. Bosch-Port Ondernemings, Proprietary, Limited v. ABSA Bank Limited 2014, 2, SA 518, SCA 525. Commercial solvency, assessed based on liquid assets available to meet obligations. Marino and others v. African Global Holdings, Proprietary, Limited and others 2020, 2, SA 93, SCA 103-4. A commercially solvent company can be wound up under the 2008 Act, even if factually insolvent. A commercially insolvent company can be wound up under the 1973 Act, even if factually solvent. Grounds for winding up. 1. Special resolution. A company, solvent or insolvent, can be wound up if it passes a special resolution, S344A, S811AI. 2. Failure to commence or continue business. A company may be wound up if it has not started its business within 1 year of incorporation or suspended business for a whole year, S344C. Applies only to insolvent companies, not mentioned in S811. 3. Loss of capital. Winding up possible if 75% of issued share capital is lost or useless, S344E. Originally intended for both solvent and insolvent companies but now applies only to insolvent companies. 4. Inability to pay debts, S344F, S345. A company is deemed unable to pay debts when a creditor, owed at least R100, demands payment, but the company fails to pay within 3 weeks, S345-1A. Afric Oil, Proprietary, Limited v. Ramadan Investments CC 2004, 1, SA35, N. A warrant of execution returns unsatisfied, S345-1B. It is proven in court that the company cannot pay debts, S345-1C. The court considers contingent and prospective liabilities, Helderberg Laboratories CC and others v. Sola Technologies, Proprietary, Limited 2008, 2, SA 627, C. Factually insolvent companies may or may not be unable to pay debts, Johnson v. Herotech, Proprietary, Limited 2000, 4, SA 930, SCA. Admission of insolvency can be relied upon even if made on a without prejudice basis, ABSA Bank Limited v. Hammerl Group 2015, 5, SA 215, SCA. 5. Dissolution of external company, S344G. A court may wind up an insolvent external company if it has been dissolved in its country of incorporation, has ceased business or only operates for winding up purposes. Legal basis. An external company in South Africa can be liquidated independently of its foreign counterpart, Saxdien Novi Proudfoot SA, Proprietary, Limited 2003, 4, SA 348, SCA. 6. Just an equitable ground, S344H, S811C, 2, S811D, 3. The court may order winding up if it is just an equitable, but it is not a catch-all provision. Rand Air, Proprietary, Limited v. Raybester Investments, Proprietary, Limited 1985, 2, SA 345, W. Examples where this applies. Substratum failure. The company's main objective is unattainable. APCO Africa, Proprietary, Limited and another v. APCO Worldwide Incorporated 2008, 5, SA 615, SCA. Illegality or fraud. The company was formed to defraud investors. Cunningham v. First Ready Development 249, 2010, 5, SA 325, SCA. Loss of confidence in management. Director's misconduct justifies loss of confidence. Musanovi Mabjibowen, Proprietary, Limited 1967, 3, SA 131, T. Management deadlock. The board/shareholders are irreconcilably divided. Kanakia v. Rich Shelf 1004 CCTA Passage to India 2003, 2, SA 39. D. Quasi-partnership breakdown, a breakdown in mutual trust among members. Ebrahimi v. Westbourne Galleries Limited 1973 AC 360, HL. Oppression of minority shareholders. If an alternative remedy is unavailable, Ma'u v. Manu Shalom Congregation 1994, 2, SA 240, W. 7. Conversion of voluntary winding up into court winding up. A solvent company involuntary winding up can apply to court for continued winding up, S 81 1A, 2. 8. No reasonable prospect of business rescue succeeding. A business rescue practitioner may apply for winding up if the company cannot be rescued, S 81 1B, Mensno v. Truckmech, Proprietary, Limited 2021 JDR 0065, GJ. This applies only to solvent companies. 9. Termination of business rescue proceedings. A company can be wound up if business rescue proceedings end under S132 2B or CI. Key cases: Boschport Ondernemings, Proprietary, Limited v. Absa Bank Limited 2014, 2, SA 518, SCA. Commercial solvency is the decisive factor for determining which act applies. Marino and others v. African Global Holdings, Proprietary, Limited and others 2020, 2, SA 93, SCA. Liquid assets and immediate obligations are key in determining solvency. Helderberg Laboratories CC and others v. Sola Technologies, Proprietary, Limited 2008, 2, SA 627, c. Payment by a third party may be considered in assessing solvency. Absa Bank Limited v. Hammerl Group 2015, 5, SA 215, SCA. Admission of insolvency can be used as evidence, even if made without prejudice. Saxton Novi Proudfoot SA, Proprietary, Limited 2003, 4, SA 348, SCA. External companies can be liquidated independently in SA. APCO Africa, Proprietary, Limited and another v. APCO Worldwide Incorporated 2008, 5, SA 615, SCA. Winding up is justifiable when the company's substratum disappears. Ebrahimi v. Westbourne Galleries Limited 1973 AC 360, HL. A quasi-partnership breakdown justifies winding up. Summary. The main distinction is whether a company is solvent, 2008 Act, or insolvent, 1973 Act. Winding up may occur through special resolution, failure to commence business, capital loss, inability to pay debts, external company dissolution, or just inequitable grounds. Just inequitable grounds include substratum failure, fraud, deadlock, quasi-partnership breakdown, and shareholder oppression. Business rescue proceedings may also lead to winding up if they fail. Key cases provide judicial interpretation of commercial solvency, just inequitable grounds, and business rescue considerations. Next page. Parties who may apply for winding up of an insolvent company. Section 346, 1973 Act, Legal Standing Requirement. The applicant must establish locus standi to bring the application. Cases: Commonwealth Shippers Limited v. Mail and Properties, Proprietary, Limited, 1978, Kyle and others v. Merritts and Peterson Incorporated, 2002. I. The company. The company itself may apply for its winding up. S 346 1A. Debate existed on whether a special resolution by members or a board resolution by directors was required. Directors could resolve to apply. Ex parte tangent sheeting, Proprietary, Limited, 1993, ex parte Graffernet Roller Mule, EDMS, VPK, 2000. Board needed authorization via Articles of Association. Ex parte Rusland Construction, Proprietary, Limited, 1987. Ex parte Screen Media Limited, 1991, ex parte New Seasons Auto Holdings, Proprietary, Limited, 2008. Companies Act 2008, S 66-1. Directors manage business and affairs of the company unless otherwise provided. The board likely has the power to apply without a special resolution. A board decision is preferable due to costs and delays of convening a members' meeting. 2. One or more creditors. A creditor, including contingent or prospective creditors, may apply. S 346 1B. No minimum claim amount required. Cf. S 345 1 applies only to proving inability to pay debts. Contingent or prospective creditors. Lender with a future repayment date. Surety for the company. Wild v. Wadolph Investments, Proprietary, Limited, 2005. Damages claimant. Gillis Mason Construction Company, Proprietary, Limited v. Overval Crushers, Proprietary, Limited, 1971. Periodic Debt Creditor, Express Model Trading 289 CCV Dolphin Ridge Body Corporate, 2015. Subordinated Debt Creditor, ABSA Bank Limited v. Hammerl Group, 2015. Exclusion, a preferred shareholders claim, Choice Holdings Limited v. Yabang Investment Holding Company Limited, 2001. 3. One or more. Next page. Next page. Winding up of an insolvent company, parties who may apply. Section 346 of the Companies Act 1973 specifies who may apply for the winding up of an insolvent company. The applicant bears the onus of proving locus standi, legal standing. Relevant cases: Commonwealth Shippers Limited v. Mail and Properties, Proprietary, Limited 1978, 1, SA 70, D, Kyle and Others v. Merritts and Peterson Incorporated, 2002, 3 All SA 223, T, _ I, the company. Next. Keep the numbering format. Page 23.2.3 Parties who may apply for winding up of an insolvent company. Section 346 of the Companies Act 1973 specifies who may apply for the winding up of an insolvent company. The applicant bears the onus of proving locus standi, legal standing. Relevant cases: Commonwealth Shippers Limited v. Mail and Properties, Proprietary, Limited 1978, 1, SA 70, D, 72. Kyle and Others v. Merritts and Peterson Incorporated, 2002, 3 All SA 223, T, 226. I, the company. The company itself may apply for its winding up, S 346 1A. Debate on whether authorization requires special resolution of members in a general meeting. Board resolution by directors. Case law. Directors may resolve to apply. Ex parte tangent sheeting, Proprietary, Limited 1993, 3, SA 488, W, Ex parte grapher net roller mule, EDMS, BPK 2000, 4, SA 670, E. Board may only apply if company's articles confer the power. Ex parte Ruslan Construction, Proprietary, Limited 1987, 1, SA 33, D. Ex parte Screen Media Limited 1991, 3, SA 462, W. Ex parte New Seasons Auto Holdings, Proprietary, Limited 2008, 4, SA 341, W. Companies Act 2008, S 66 1. Directors manage the company's business and affairs. Board may exercise all powers unless restricted by law or the memorandum. Board resolution preferred due to cost effectiveness, avoids expensive member meetings, prevents delays that could harm the company, creditors, or expose directors to reckless trading charges. See 23.12. _ 2. One or more creditors. Any creditor, including contingent or prospective creditors, may apply. S 346 1B. Key aspects: no minimum claim amount required, unlike compulsory sequestration. Liquidated claim of R100, S 345 1A, only relevant for proving insolvency. Who qualifies as a contingent or prospective creditor? Lender with future repayment date. Surety for company's debt. Wild and Another v. Wadolph Investments, Proprietary, Limited and Others 2005, 1, SA 354, W. 358. Damages claimant awaiting court quantification. Gillis Mason Construction Company, Proprietary, Limited v. Overval Crushers, Proprietary, Limited 1971, 1, SA 524, T. Recurring Debt Creditor, Express Model Trading 289 CCV Dolphin Ridge Body Corporate 2015, 6, SA 224, SCA, 233. Subordinated Creditor, ABSA Bank Limited v. Hammerl Group 2015, 5, SA 215, SCA, 218. Who does not qualify? Preferred shareholder, Choice Holdings Limited and Others v. Yabang Investment Holding Company Limited 2001, 3, SA 1350, W, 1356-7. _ 3. One or more of its members. Members, shareholders, may apply. S 346 1C, S 133. Restrictions on member applications. Must be registered in the Register of Members for at least 6 months before applying. Exception: if shares were inherited from a deceased shareholder. Cannot apply on certain grounds, S 346-2, including special resolution winding up, C 23.2.2I. Company's inability to pay debts, C 23.2.2Vi. Dissolution of an external company, C 23.2.27. Ways members can initiate winding up. 1. Special resolution for a member's voluntary winding up. 2. Special resolution for a creditor's voluntary winding up. 3. Special resolution for the company to apply for a court order. 4. Individual application to court, restricted grounds in S 344, cannot rely on insolvency. 4. Any or all of the above parties. Joint applications by any combination of company, creditors, members, S 346-1D. V. The master may apply to convert a voluntary winding up into a court-ordered winding up, S 346-1E. Purpose of conversion: enables examination and inquiry procedures, SS 417, 418, usually based on company's inability to pay debts. By a provisional or final judicial manager. Provisional judicial manager may apply when provisional judicial management order is discharged, S 346-1F. Does not prevent creditors from applying for winding up. Confreeze, Proprietary, Limited V1 and 8 Investments, Proprietary, Limited 1996, 1, SA 759, C, 762-3. Final judicial manager must apply for winding up if company will not become a successful concern, S 433L. Judicial management repeal. Judicial management abolished under Companies Act 2008. Still relevant for judicial managers appointed under the 1973 Act before May 1, 2011. Next page. 23.2.4 Parties who may apply for winding up of a solvent company. Section 81(1) of the Companies Act 2008 specifies who may apply for the winding up of a solvent company. Locus standi, legal standing, depends on the grounds for the application. Eligible applicants and grounds for application. Special resolution: the company, S 81(1)AI. Just and equitable grounds: the company, one or more directors, one or more shareholders, or one or more creditors, S 81(1)D, S 81(1)C. 2. Conversion of voluntary winding up into court-ordered winding up the company, S 81(1)A. 2. No reasonable prospect of business rescue succeeding the business rescue practitioner, S 81(1)B. Termination of business rescue proceedings: one or more creditors, S 81(1)CI. Deadlock in management or voting the company, one or more directors, or one or more shareholders, S 81(1)D. Fraud, illegality, or misapplication of company assets: any shareholder requires court leave, S 81(1)E. Failure to comply with a compliance notice: the Companies and Intellectual Property Commission, CIPC, or the Takeover Regulation Panel, S 81(1)F. Restrictions on shareholder applications. Shareholders cannot apply on the grounds of deadlock in management or voting, fraud, illegality, or misapplication of assets. Exception: shareholder, or the person from whom shares were acquired, must have held shares continuously for at least 6 months before the application, S 81(2). 23.2.5 Steps prior to application. Uncertainty on application of Section 346. S 346 of the Companies Act 1973 imposes requirements for winding up applications. Question: do these apply to solvent companies under S 81 of the 2008 Act? Best view: compliance is required for effective application of SS 79 to 81, SCH 5, Item 92, S 79-2. I. Security for costs. Applicant must provide security for costs. Covers fees, charges, and liquidation costs until a provisional liquidator is appointed. If no liquidator is appointed, covers costs until winding up is discharged. S 346-3. Master's certificate, issued within 10 days before filing, confirms that security has been provided. 2. Master's report. Applicant must serve a copy of the application on the master before filing. Master may report on facts justifying postponement or dismissal of the application, S346-4. Western Cape Practice Note No. 5, 2004, SA 135, C, mandates the master's report before setting the application down. _ 3. Notification of interested parties. Applicant must notify S346-4 4. Registered trade unions representing employees by posting a copy of the notice on a notice board accessible to employees if no access, at the front gate or front door of business premises. South African Revenue Service, SARS. The company itself, unless the company is the applicant or the court dispenses with notice. Notification to employees. Mandatory, but method of delivery is flexible. Alternative methods permissible if they ensure accessibility. EB Steam Company, Proprietary, Limited v. Eskom Holdings Soak Limited 2015, 2, SA 526, SCA 534-6. Court cannot issue a final winding up order until notice requirements are met. Item 537-8. Affidavit requirement. Before or at the hearing, the person responsible for notification must file an affidavit confirming compliance, S346-4AB. Next page. Winding up of a solvent company. 23.2.4 Parties who may apply for winding up. Section 81(1) of the Companies Act 71 of 2008 specifies who may apply for the winding up of a solvent company. Special resolution, the company itself. Just on equitable grounds, the company, one or more directors, shareholders, or creditors, S81(1)(d), S81(1)(c), 2. Conversion of voluntary winding up into court-ordered winding up, the company, S81(1)(a), 2. No reasonable prospect of business rescue succeeding, the business rescue practitioner, S81(1)(b). Termination of business rescue proceedings, one or more creditors, S81(1)(ci). Deadlock in management or voting, the company, one or more directors, or one or more shareholders, S81(1)(d). Fraud, illegality, or misapplication of company assets, any shareholder, with leave of the court, S81(1)(e). Failure to comply with a compliance notice, the Companies and Intellectual Property Commission, CIPC, or Takeover Regulation Panel, S81(1)(f). Restrictions on shareholder applications. A shareholder may not apply on the basis of deadlock, fraud, illegality, or misapplication of assets unless they have held shares, or their predecessor has, for at least 6 months before the application, S81(2). 23.2.5 Steps prior to application. Legal requirements for winding up applications. Security for costs, S346-3. Applicant must provide security for costs incurred during winding up. A master's certificate, issued within 10 days before application, is required as proof. Master's report, S346-4. Applicant must serve a copy of the application on the master, who may report any facts justifying postponement or dismissal. Filing a master's report is a precondition for the application. Western Cape Practice Note No. 5. Notification to interested parties, S346-4A. Trade unions representing the company's employees. Employees via notice board, gate, or door at company premises. South African Revenue Service, SARS. The company itself, unless it is the applicant or the court exempts it. Filing of affidavit. The applicant must submit an affidavit confirming that these notifications have been made, S346-4AB. Court cannot make a final order until notifications are confirmed. EB Steam Company, Proprietary, Limited v. Eskom Holdings Soak Limited 2015, 2, SA 526, SCA 23.2.6 Powers of the Court. The court cannot grant a winding up order under S81(1)(e), fraud, illegality, misapplication, or S81(1)(f), failure to comply with compliance notice, if the implicated directors resign or are removed, and the remaining directors were not materially involved. Shareholders apply for a delinquency order against the responsible directors, and the court is satisfied that their removal will stop the misconduct, S81(3). The court may grant, dismiss, or adjourn the application conditionally or unconditionally, S347(1). Issue a provisional winding up order if the applicant makes a prima facie case, followed by a rule nisi. Johnson v. Herotech, Proprietary, Limited 2000, 4, SA 930, SCA. Discretionary powers of the court. The court has discretion to grant or refuse a winding up order, regardless of the ground. SA Distributors, Proprietary, Limited v Sport and Spell, EDMS, VPK 1973, 3, SA 371, C. Preference for business rescue over winding up if viable, Van Niekerk v Saraso 321 cc in another, 2012. Zuchk 63. A creditor's right to a winding up order is no longer absolute due to the introduction of business rescue, Southern Palace Investments 265, Proprietary, Limited v Midnight Storm Investments 386 Limited 2012, 2, SA 423, WCC. When winding up is preferred over business rescue, dispositions need to be set aside. Engen Petroleum Limited v Multi-Waste, Proprietary, Limited 2012, 5, SA 596, GSJ. Company is involved in legal disputes that a liquidator can resolve, for example, terminating leases. Shareholder deadlock. Lack of financial information on the company. First Rand Bank Limited v Imperial Crown Trading 143, Proprietary, Limited 2012, 4, SA 266, KZD. The court cannot refuse a winding up order solely because the company has no assets or its assets are fully mortgaged. S347-1. There is no advantage to creditors. Securefin Limited v KNA Insurance and Investment Brokers, Proprietary, Limited, 2001, 3 All SA 15, T. Disputed facts in a winding up application. If the company disputes the creditor's claim, the court may grant a provisional winding up order only if requirements are established on a balance of probabilities. Reynolds No v Mecklenburg, Proprietary, Limited 1996, 1, SA 75, W. The company must provide evidence that it disputes the debt in good faith. Calio v Decotex, Proprietary, Limited 1988, 1, SA 943, A. A prima facie case is not enough if the company's dispute is genuine. Payslip Investment Holdings CCBY2K Tech Limited 2001, 4, SA 781, C. Failure to pursue a counterclaim may indicate the dispute is fabricated. Afgri Operations Limited v Hams Fleet, Proprietary, Limited 2022, 1, SA 91, SCA. Alternative remedies instead of winding up. If another remedy, such as relief under S163, oppressive or prejudicial conduct, is available, the court may refuse the winding up. S347-2, Robson v Waxworks, Proprietary, Limited 2001, 3, SA 1117, C. If a shareholder breaches a shareholder agreement, they may be denied winding up relief. Theron v Phoenix Marketing, Proprietary, Limited 1998, 4, SA 287, W. Next page. Study notes. Winding up of companies. 23.2.6 Powers of Court. The court cannot grant a winding up order under S81(1)(e), fraud, illegality, or misapplication of assets, S81(1)(f), failure to comply with a compliance notice, if implicated directors resign or are removed and the remaining directors are not involved. If shareholders apply for delinquency against the responsible director and the court finds removal sufficient to end misconduct, S81(3) of the 2008 Act. Court's discretion in winding up applications. Can grant, dismiss, adjourn, or issue interim orders. S347(1). Typically, a provisional winding up order is made first, allowing interested parties to object. Rule nisi issued. The court may immediately issue a final order if issues are fully ventilated. Johnson v Herotech, Proprietary, Limited 2000, 4, SA 930, SCA 934-5. Court's power to grant a winding up application is discretionary, regardless of the grounds. SA Distributors, Proprietary, Limited v Sport and Spell, EDMS, VPK 1973, 3, SA 371, C. 373. Preference for business rescue over winding up. Business rescue is preferred over liquidation when feasible. Van Niekerk v Saraso 321 cc in another, 2012, Zuchk 63. Courts have shifted from automatically granting winding up for inability to pay debts. Southern Palace Investments 265, Proprietary, Limited v Midnight Storm Investments 386 Limited 2012, 2, SA 423. WCC. However, winding up remains appropriate when the company's dispositions need to be set aside. Engen Petroleum Limited v Multi-Waste, Proprietary, Limited 2012, 5, SA 596, GSJ. The company is involved in legal disputes, for example, lease terminations. There is a deadlock between shareholders. There is insufficient financial information on the company. First Rand Bank Limited v Imperial Crown Trading 143, Proprietary, Limited 2012, 4, SA 266, KZD. Other court considerations in winding up. Court cannot refuse winding up just because the company has no assets or its assets are fully mortgaged. S347-1. No requirement to prove winding up benefits creditors. SecureFin Limited v KNA. Insurance and Investment Brokers, Proprietary, Limited, 2001, 3 All SA 15, T, 27. If factual disputes exist, a provisional order may only be granted if the court is satisfied on a balance of probabilities. Reynolds No v Mecklenburg, Proprietary, Limited 1996, 1, SA 75, W, 81. Good faith dispute of debt may prevent a winding up order. Khalil v Decotex, Proprietary, Limited and another 1988, 1, SA 943, A, 980-2. Company's burden in debt disputes. If debt is established prima facie, the company must prove the dispute is genuine. Afgri Operations Limited v Hams Fleet, Proprietary, Limited 2022, 1, SA 91, SCA, 98. Failure to pursue counterclaims suggests the dispute is fabricated. IBID. Alternative remedies. Court will not grant winding up if another remedy is available, such as relief under S-163 of the 2008 Act, Robson v Waxworks, Proprietary, Limited and others 2001, 3, SA 1117, C, 1122. Court refused winding up where shareholder failed to offer shares as per agreement. Theron v Phoenix Marketing, Proprietary, Limited 1998, 4, SA 287, W, _. 23.3 Voluntary winding up. Insolvent company may voluntarily wind up if a special resolution is adopted. S349. The Commission registers the resolution under S200, S351, S351-1. The resolution must state whether it is a member's voluntary winding up or creditor's voluntary winding up. Bodeno v Van den Heever No 2012 JDR 1202, GNP. Solvent company may voluntarily wind up if it adopts a special resolution and files it with the Commission. S81, 2 of the 2008 Act. The resolution must specify whether the winding up is by the company or by creditors. S81 of the 2008 Act. _. 23.3.1 Members voluntary winding up and voluntary winding up by company. Available only if the company can pay its debts in full. Requirements before proceeding. Security must be provided for full debt payment within 12 months. Alternatively, the master may waive security if directors submit an affidavit stating the company has no debts. An auditor, or qualified individual, certifies the company has no debts. S351, S83 of the 2008 Act. Reasons for members' voluntary winding up. Purpose of the company has been fulfilled. Shareholders running the company are no longer amicable. Simpler and quicker than court-ordered or creditors' voluntary winding up. Controlled by members. Creditors do not prove claims or hold meetings. A factually/commercially insolvent company can still do this if it arranges security for full payment. Shareholder rights. Shareholders cannot be denied the right to pass a special resolution for winding up. Court will not interfere with the majority's decision. National Union of Leather Workers v Barnard and Perry NNO 2001, 4, SA 1261, LAC, 1267. _. 23.3.2 Creditors voluntary winding up. Available when the company cannot pay its debts. Applies to solvent and insolvent companies. S79-1A, 2, of the 2008 Act, S343-2A, S351. Suitable if a solvent company has debts but cannot or will not furnish security for full payment. Process similar to court-ordered winding up. Creditors hold meetings. The liquidator follows creditors' directions. Also called voluntary winding up under creditors' supervision. Directors must prepare and submit a statement of the company's affairs before the meeting. S363-1. Criminal provisions. Certain criminal provisions of winding up by court do not apply to creditors' voluntary winding up. S425. Next page. Study notes, voluntary winding up and consequences. Underscore. 23.3 Voluntary winding up. Insolvent company may be voluntarily wound up if special resolution is adopted, S 349. Commission registers resolution as per S 200, SS 351 and 351-1. Case, Bodeno v. Van den Heever No 2012 JDR 1202, GNP. Solvent company may be voluntarily wound up if special resolution is adopted and filed with the Commission, S 81, 2, 2008 Act. Resolution must provide for either winding up by the company, winding up by creditors, S 81, 2008 Act. 23.3.1 Members voluntary winding up and voluntary winding up by company. Only possible if the company can pay debts in full. Prerequisites. Security must be furnished for debt payment within 12 months, or master may dispense with security if directors submit an affidavit stating no debts. Auditor, or qualified person, certifies company has no debts, S 351, S 83, 2008 Act. Reasons for voluntary winding up. Purpose of the company is fulfilled. Internal conflicts between members. Key characteristics. Simpler and faster than court/creditors voluntary winding up. Members control the process. Creditors do not prove claims or hold meetings. Court stance. Right to voluntary winding up by shareholders resolution cannot be excluded from articles of association. Court will not interfere with shareholders' decision to wind up the company. Case, National Union of Leather Workers v. Barnard and Perry NNO 2001, 4, SA 1261, LAC, 1267. 23.3.2 Creditors voluntary winding up. Used when a company cannot pay debts. Can be applied to solvent or insolvent companies, S 79 1A, 2, 2008 Act, S 343 2A, S 351. Reasons for a solvent company to choose this. Cannot or will not furnish security for full debt payment. Procedure. Similar to court-ordered winding up. Creditors hold meetings and direct liquidator. Resembles voluntary winding up under creditor's supervision. Directors must submit a statement of affairs before passing resolution, S 363-1. Criminal provisions. Some provisions applying to court winding up do not apply here, S 425. Underscore. 23.4 Consequences of winding up. 23.4.1 Commencement of winding up. Court-ordered winding up of an insolvent company begins at the time the application is lodged with the registrar, S 348. Case, Nell and others NNO v. The Master and others 2002, 3, SA 354, SCA, 358. At the time means a specific moment, not the whole day. Development Bank of Southern Africa Limited v. Van Rensburg and others NNO 2002, 5, SA 425, SCA. 431-2. If multiple applications are made. Winding up starts when any application is lodged. First National Bank Limited v. EU Civils, Proprietary, Limited 1996, 1, SA 924, c. Even if final order is granted based on a different application, nil case. Court-ordered winding up of a solvent company starts when a special resolution for winding up is adopted. The company applies to convert voluntary winding up into court-ordered winding up. A business rescue practitioner applies for liquidation, S 81-4A, read with S 81-1A, B. In other cases, winding up begins when the court grants the order, S 81-4B. Voluntary winding up commencement. Insolvent company, when members' special resolution is registered, S 352-1. Solvent company, when special resolution is filed with the Commission, S 86. Importance of commencement date. Determines the legal consequences of winding up. Effects arise from the moment winding up begins, not when final order is granted. 23.4.2 Directors divested of powers and control. Winding up creates a concursus creditorum. Ensures equal distribution of assets among creditors. Case, Taylor and Stein NNOV Kokima were 1982, 1. SA 374, T. 377. Provisional order also creates concursus creditorum, Excellent Petroleum, Proprietary, Limited, in liquidation, v. Brent Oil, Proprietary, Limited 2012, 5, SA 407, GNP. Effects on the company. Corporate identity remains, S 353-1, S 88A, 2008 Act. Ownership of assets remains unless court orders otherwise. S. 361-3. Effects on directors. Directors' powers cease, they become functus officio. Attorney General v. Blumenthal 1961, 4, SA 313, t. S. 353-2. Exception: involuntary winding up, liquidator, creditors, or members may allow directors to retain powers. S. 353-2, S. 88b, 2, 2008 Act. Effects on company assets. Company retains ownership but assets are under master's control until a provisional liquidator is appointed. S. 361-1, 2. Section 339 does not apply. Provisions of S. 21C of the Insolvency Act to company liquidations, leaving Ungu Trading 353, Proprietary, Limited 2008, 2, SA 1, SCA. Business operations. Company must stop trading unless necessary for winding up. Let's Stores, Proprietary, Limited v. Rhodes and Others 1958, 2, SA 224, t. S. 353-1, S. 88bi, 2008 Act. Next page. Study notes, consequences of winding up. 23.4.1 Commencement of winding up. Court-ordered winding up of an insolvent company starts when the application is lodged with the registrar. S. 348. Confirmed in Nell and Others NNOV The Master and Others 2002, 3, SA 354, SCA 358. At the time means the exact moment, not the whole day. Development Bank of Southern Africa Limited v. Van Rensburg and Others NNO 2002, 5, SA 425, SCA 431-2. If multiple applications are made, winding up begins when the first is lodged, regardless of which one is granted. First National Bank Limited v. EU Civils, Proprietary, Limited 1996, 1, SA 924, c. A provisional winding up order replaced by a final order still results in the winding up commencing on the date of the original application. Nel case supra. Court-ordered winding up of a solvent company begins when an application has been made on these grounds. Company has adopted a special resolution for winding up. Company applies to convert voluntary winding up into court-ordered winding up. Business rescue practitioner applies for liquidation due to no reasonable prospect of rescue. S. 81-4 read with S. 81-1a, b. In all other cases, winding up starts when the court issues the order. S. 81-4b. Voluntary winding up. Insolvent company begins when the member's special resolution is registered with the Commission. S. 352-1, Bodeno v. Van den Heever No 2012 JDR 1202, GNP. Solvent company begins when a special resolution is filed with the Commission. S. 86. Importance of determining commencement. Various legal consequences take effect from the moment winding up commences, not from the date of a provisional or final order. 23.4.2 Directors divested of powers and control. Winding up creates a concursus creditorum, a collective process ensuring fair asset distribution. Established when a winding up order is granted, even if provisional. Taylor and Stein NNOV Kokima were 1982, 1, SA 374, t. 377. Confirmed in Excellent Petroleum, Proprietary, Limited, in liquidation, v. Brent Oil, Proprietary, Limited 2012, 5, SA 407, GNP. Effects of commencement of winding up. Directors lose their powers and become functus officio. Attorney General v. Blumenthal 1961, 4, SA 313, t. S. 353-2. Involuntary winding up. Directors may continue acting if sanctioned by the liquidator, creditors, or members. S. 353-2, S. 88b, 2. Of the 2008 Act. Company's property falls under the control of the master until a liquidator is appointed. S. 361-1, 2. The company retains ownership of its assets unless otherwise ordered. S. 361-3. Section 339 does not incorporate S. 21C of the Insolvency Act, meaning the company is not divested of assets, leaving Ungu Trading 353. Proprietary, Limited and Another 2008, 2, SA 1. SCA. Company cannot continue business except for activities necessary for winding up. Let's Stores, Proprietary, Limited v. Rhodes and Others 1958, 2, SA 224, t. S. 353-1, S. 88bi of the 2008 Act. Next page. Study notes, consequences of winding up, continued 23.4.3 subsequent unauthorized dispositions void. Once winding up commences, any transfer of shares without the liquidator's permission is void, S341-1. If the company cannot pay its debts, all unauthorized dispositions of its property, including rights of action, are void, S341-2. Confirmed in Schmidt and another NNOV ABSA Bank Limited 2002, 6, SA 706, W. 712-13. Set-off can occur only if mutuality of claims existed at the time of winding up. Thorne and another NNOV The Government 1973. 4. SA 42, T. Court discretion on unauthorized dispositions. Court considers fairness, justice, and creditor interests. Gainsford and others NNOV Tanser Transport, Proprietary, Limited 2014. 3. SA 468, SCA. 478. Exceptions are rare and must align with the objectives of the Act. Discretion applies only to dispositions made after deemed commencement but before a winding up order. Pride Milling Company, Proprietary, Limited v. Becker No and another 2022. 2. SA 410, SCA, 422. 23.4.4 Stay of proceedings. Effect of the winding up order or voluntary winding up resolution. All civil proceedings against the company are suspended until a liquidator is appointed. S359-1A includes enforcement of judgments. Richard Key Pollock Novi North Copper Wire, Proprietary, Limited, 2002, 1 All SA 244, T. 246. An application for winding up is not a civil proceeding and can proceed despite a voluntary winding up resolution. King Pie Holdings, Proprietary, Limited v. King Pie, Pinetown, Proprietary, Limited 1998. 4. SA 1240, D. Attachments and executions against company assets are void. S359-1B applies if assets are seized under a writ of execution. The Nantai Princess, Nantai Line Company Limited v. Cargo Laden on the MV Nantai Princess 1997. 2. SA 580, D. Defined as sheriff taking possession of the property. Brenny Novi Registrar of Deeds and another 1977. 2. SA 513, C. 515, LL Mining Corporation Limited v. Namco, Proprietary, Limited, in liquidation, 2004. 3. SA 407, C. 411-12. Sales in execution pending at commencement of winding up. Sheriff cannot transfer property to the buyer. Seifert's Bank Limited v. Sheriff of the Supreme Court, Durban Central 1997. 1. SA 764, D. Contra, Shuri v. Sheriff for the Supreme Court, Winburg 1995. 4. SA 709, C. CF, Atkins v. Registrar of Deeds, Johannesburg 2012. 6. SA 278, GSJ. Proceedings after liquidator appointment. Civil cases may continue if the litigant gives at least 3 weeks' notice within 4 weeks of the liquidator's appointment. S359-2 includes execution proceedings started before winding up. If company property is already attached, the creditor can proceed with execution after notice to the liquidator. Creditor has no preference and proceeds, except for execution costs. Stridum Novi MGN Construction, Proprietary, Limited, in Rehilian, Proprietary, Limited, in liquidation, 1983, 1, SA 799, D. Notice requirement benefits the liquidator. If the defendant is a surety, notice to the liquidator is not required. Nedker Bank Limited v. Samuel and others 2005, 2, SA 439, W. 441. Failure to give notice equals abandonment of proceedings, unless the court allows continuation. S359-2B. The court has full discretion and considers interests of creditors, liquidators, and members. Ronville 108, Proprietary, Limited v. Sublime Investments, Proprietary, Limited, in liquidation, 2010, 2, SA 517, SCA. Next page. Study notes, consequences of winding up, continued 23.4.5 Notice of winding up. Obligations upon receipt of a winding up order. The master must publish notice of the winding up in the Gazette, S356-1 and 2b. The registrar of the court must send a copy of the winding up order to relevant sheriffs. Registrars of Deeds, S357-1 and 3. Service of winding up order. Must be served on S346A1. Any registered trade union representing the company's employees by posting a copy on a notice board accessible inside the premises, on the front gate or front door of the business premises where the application was made. South African Revenue Service, SARS. The company itself, unless it initiated the application. The sheriff must determine whether a trade union represents the employees. Employees have access to a notice board inside the premises, S346A2. If employees are no longer at the premises, personal notification is considered substantial compliance. Hendricks No and Others v. Cape Kingdom. Proprietary, Limited 2010, 5, SA 274, WCC. Notice requirements for voluntary winding up of an insolvent company. Company must publish notice in the Gazette within 28 days of registering the resolution. Company must lodge a certified copy of the resolution with the master, along with members' voluntary winding up, a certified copy of any resolution nominating a liquidator, S356-2AI. Creditors' voluntary winding up, 2 certified copies of a statement of company affairs, S356-2A, 2. Voluntary winding up of a solvent company. The Companies and Intellectual Property Commission, CIPC, must deliver a copy of the filed resolution to the master, S87 of the 2008 Act. Next page. Study notes, consequences of winding up, continue 23.4.6 Lodging of Statement of Affairs with the master. Requirement after a winding up order. Directors and officers must prepare a statement of affairs in the prescribed form. 2 certified copies must be lodged with the master within 14 days of the winding up order, or a longer period if allowed by the master or the court. S363-2. The master may require any person who was a director or officer during the year before the winding up order involved in the formation of the company. The master must send a copy of the statement to the liquidator upon appointment. S363-5. _ 23.5 Meetings and proof of claims. 23.5.1 Creditors' meetings. Applicability. Required in court-ordered winding up and creditors' voluntary winding up. At least 2 creditors' meetings must be held. S364-1. First meeting must be convened as soon as possible after the final winding up order by the court. Registration of the special resolution for creditors' voluntary winding up. Purpose. Consideration of company's statement of affairs. Proof of claims against the company. Nomination of a liquidator, S364-1. Second meeting must be convened in the same manner as creditors' meetings under the Insolvency Act, S412-1. Further meetings can only be held with court authorization, S413. Obligations of directors and officers. If the company cannot pay its debts, directors and officers must attend the first and second creditors' meetings, S414-1. The master may subpoena others for interrogation, S414-2. Interrogation may occur after the first and second meetings, even after the final account has been confirmed. Standard Bank of SA Limited v. The Master and Others 1999, 2, SA 257, SCA. _ 23.5.2 Members' meetings. Applicability. Required in court-ordered winding up and creditors' voluntary winding up. Purpose. Must be convened as soon as possible after the final winding up order. The special resolution for voluntary winding up has been registered or filed, S364-1B. Consideration of company's statement of affairs. Nomination of a liquidator, S364-1B. Exemption. If the company resolved these matters in a general meeting before passing the winding up resolution, no additional meeting is required. IBID. Further meetings. The court may order additional meetings of members, S413. Meetings must be held in accordance with Companies Act regulations, S364-2, S412-1. Next page. Study notes, consequences of winding up, continue 23.5.3 Proof of claims. Court-ordered and creditors' voluntary winding up. Creditors must prove claims against the company at creditors' meetings mutatis mutandis with the Insolvency Act, S366-1. The liquidator may apply to the master to set a deadline for proving claims, S366-2. The general period for proving claims is governed by S44-1 of the Insolvency Act. The master has discretion to allow late claims. Wishart No and Others v. BHP Billiton Energy Coal South Africa, Proprietary, Limited and Others 2017, 4, SA 152, SCA, 155, Mayono and Others v. the Montalhood 2016, 1, SA 36, SCA. Members voluntary winding up. No need to prove claims. The liquidator settles debts, realizes assets, and submits the liquidation and distribution account to the master. _ 23.6 The liquidator. 23.6.1 Appointment of provisional liquidator. When appointed. After a winding up order, a special resolution for voluntary winding up is registered. The master appoints a suitable person. S368. The court cannot appoint a provisional liquidator. City Capital SA Property Holdings Limited v. Chavons Badenhorst St. Clair Cooper and Others 2018, 4, SA 71, SCA, 84. Duties and restrictions. Must give security to the master. Holds office until a liquidator is appointed. The master may limit the provisional liquidator's powers. S386-6. Can seek court approval for necessary winding up actions. Forino Villaroo and Others 2006, 1, SA 279. T. 285-6. Policy considerations. The Minister determines policy for provisional liquidator appointments, S158-2 of the Insolvency Act. The 2014 policy was declared unconstitutional. Minister of Justice and Another VSA Restructuring and Insolvency Practitioners Association and Others 2018, 5, SA 349, CC. _ 23.6.2 Appointment of liquidator. Who appoints the liquidator? The master appoints based on nominations. Members voluntary winding up, the nominee in the special resolution, S369-1. Creditors voluntary winding up and court-ordered winding up. First creditors meeting and initial members meeting nominate a liquidator, S369-2A. If different nominees are chosen, the master decides whether to appoint one or both, S369-2B. Master's discretion. Can decline to appoint if the nominee was not properly nominated. The nominee is disqualified. The nominee fails to provide security. S371. Additional appointments. The master may appoint a co-liquidator at any time. S374. Challenging the appointment. Any aggrieved person may request the master to submit reasons to the minister. S371-1, 3. The minister can confirm or set aside the master's decision. Case law interpretations. Narrow interpretation. Only a person whose nominee was rejected is considered aggrieved. Janse van Rensburg v. the Master and Others 2004, 5, SA 173, t. Broad interpretation. Any creditor or member with a legal grievance qualifies. Gejelt v. the Master and Others 2005, 4, SA 460, c. 464-5. Remedy does not apply to provisional liquidator appointments. Minister of Justice v. First Rand Bank Limited and Others 2003, 6, SA 636, SCA, 642. Next page. Study notes. The liquidator, continued. 23.6.3 Persons disqualified from being liquidator. Under S372A, J. The following persons cannot be nominated or appointed as a liquidator. An insolvent, a minor or any person under legal disability, a person declared dishonest or abusive of their position, a person removed from an office of trust by the court or disqualified from being a director, a body corporate, a person convicted of theft, fraud, forgery, uttering a forged instrument, or perjury, sentenced to imprisonment without the option of a fine, or a fine exceeding R20. A person who induced or attempted to induce another to vote for or appoint them as liquidator through misrepresentation or reward. A person who does not reside in South Africa. A person who is a director, officer, or auditor of the company within 12 months before winding up. Exception. An auditor may act as liquidator in a member's voluntary winding up. A person acting as an agent for a creditor at a creditor's meeting. Business rescue practitioners who acted during business rescue proceedings cannot be appointed as liquidator if the company is wound up. S144 of the Companies Act 2008. _ 23.6.4 Removal of liquidator from office. A liquidator may be removed before completing duties under S379-1. The master may remove the liquidator if The liquidator was not qualified for appointment or has become disqualified. The appointment was illegal for any reason. The liquidator has not performed duties satisfactorily. The liquidator's estate became insolvent or they are mentally/physically incapable of acting. A majority of creditors, by number and value, or, in a member's voluntary winding up, a majority of members, request removal in writing. The master believes the liquidator is no longer suitable. The court may remove the liquidator if the master fails to remove them, and the removal would be to the general advantage and benefit of all interested parties. S. 379-2. Case law considerations. Professional reputation impact. Hudson and others NNOV Wilkins No and others 2003, 6, SA 234, T. 239. Cost, disruption, and inconvenience of appointing a new liquidator. Ma Africa Grobelange, Proprietary, Limited and another V. Millman and Powell NNO and another 1997, 1, SA 547, C. 566. Next page. Study notes, duties of a liquidator. 23.7.1 General function. The liquidator's primary duty is to take possession of all movable and immovable property of the company, realize the property in the prescribed manner, apply proceeds to pay winding up costs, creditors' claims, distribute the remaining balance to members. S. 391. This statutory duty overrides any mandate from a creditor or agreements made on behalf of the company. Commissioner, South African Revenue Service v. Stan 29 Not Winberg, Proprietary, Limited and others 2005, 5, SA 583, SCA 587. Directions and guidance. In court-ordered or creditors' voluntary winding up, the liquidator must follow directions given by creditors or members. S. 387-1, S. 351-2. If no directions, or conflicting ones, are given, the liquidator may seek directions from the master. If the master does not provide guidance, the liquidator may apply to the court. S. 387-2, 3. Fiduciary duty and impartiality. The liquidator must be detached, independent, impartial, and even-handed. Seen to be impartial. Grounds for removal under S. 379-2 include losing independence or siding with one party in a dispute. James v. Magistrate, Winberg and others 1995, 1, SA 1, C. 14. Actual or apparent conflict of interest, due to relationships with the company or stakeholders. Ma Africa Grobelange, Proprietary, Limited and another V. Millman and Powell NNO and another 1997, 1, SA 547, C. Hudson and others NNO v. Wilkins No and others 2003, 6, SA 234, T. 240-1. Failure to act objectively in group insolvencies, for example, when acting as a liquidator for multiple companies in the same corporate group. Standard Bank of South Africa v. the Master of the High Court and others 2010, 4, SA 405, SCA. Joint liquidators must act jointly in performing duties. Actions by only one joint liquidator, for example, obtaining a search warrant alone, are invalid. Powell and another v. Leach and another, Leach and others v. Powell and others, 1997. For all SA 106, W, _. 23.7.2 Providing information. The liquidator must provide the master with information. Allow the master access to company books and documents. S. 392. _. 23.7.3 Keeping records. The liquidator must keep records of all money, goods, books, accounts, and documents received on behalf of the company. S. 393-1. Allow inspection of records by the master. Any creditor. S. 393-2, 3. _. 23.7.4 Bank account and investments. The liquidator must open a current account in the company's name with a bank. Deposit all received money into this account. S. 394-1. Open a savings account for funds not immediately needed for paying debts. S. 394-1. Next page. Study notes, duties of a liquidator. Continue 23.7.5 Exposure of offenses. The liquidator must examine the company's affairs and transactions before winding up to determine if any present or former directors/officers have contravened the act or committed any offense. S. 401. There are grounds for disqualification of any director under S. 219, IBID. A full report must be submitted to the master before lodging the final account. S-402. The report is forwarded to the Director of Public Prosecutions if necessary. S-403. If there are grounds for director disqualification, the Director of Public Prosecutions brings the application. S-401. Underscore. 23.7.6 Report to creditors. Deadline, not later than 3 months after appointment. S-402. Extension, the master may grant more time. IBID. Report must include S-402A, I. Company's issued capital and estimated assets/liabilities. Causes of failure, if applicable. Whether the liquidator has reported or intends to report contraventions by directors. Whether any director/officer is personally liable for damages or debts under the Act. Any pending or possible legal proceedings by or against the company. Whether a further inquiry is needed regarding company formation, failure, or business conduct. Whether the company kept proper accounting records as required by law. Progress and future prospects of the winding up. Any other relevant matters or matters requiring creditors' directions. Underscore. 23.7.7 Liquidation and distribution account. I. Preparation and lodging. Deadline, within 6 months of appointment, the liquidator must lodge a liquidation and distribution account, or liquidation and contribution account, if necessary. S-403-1. Extension, the master may grant more time. S-404. Proceeds must be applied according to insolvency law. S-342. First, winding up costs, charges, and expenses. Then, creditors' claims. 2. Inspection. The account must be available for inspection at the master's office, the magistrate's office in the district of the company's registered office, if no master's office is available. Other magistrate offices in districts where the company operated. S-406-1. Minimum inspection period, 14 days, determined by the master. S-406-1. Objections. Any interested person may inspect and lodge an objection to the account. S-407-1. The master may either reject or sustain the objection and direct the liquidator to amend the account. S-407-2. An aggrieved person may, within 14 days, apply to the High Court to set aside the master's decision. S-407-4. Tunget Paper Company, Proprietary, Limited B. The Master and Others 2011, 2, SA-17. KZP. The court will not interfere with the master's ruling unless there are new facts or clear irregularities. Van Sale Novi The Master 2000, 3, SA 602, C. 607. A person cannot bypass S-407-4 and approach the court directly to expunge a claim. Wishart No and Others v. BHP Billiton Energy Coal South Africa, Proprietary, Limited and Others 2017, 4, SA 152, SCA 159. 3. Confirmation of the account. Once the account has lain open for inspection and objections are resolved, the master must confirm it. S-408. A confirmed account has the status of a final judgment. IBID. Underscore. 23.7.8 Distribution of assets. After confirmation, the liquidator must distribute assets or collect contributions in accordance with the account. S-409. Any remaining assets, after paying costs and creditors, must be distributed among members according to their rights and interests. S-342, unless the memorandum/articles provide otherwise. Next page. Study notes. Powers of the liquidator. 23.8 Powers of liquidator. A liquidator has various powers, some of which require master's consent, creditor/member authority, or court approval. The liquidator may seek court leave to raise money on the security of company assets, perform any other action necessary for winding up an asset distribution. S-386-5. If a provisional liquidator applies for leave, the court need not consider the probability of a final order but must assess whether the powers sought are necessary for the fiduciary mandate. Moodley No and Others v. Hendricks No and Others 2011, 2, SA 199, WCC 212. Underscore. 23.8.1 Powers for which no permission is required. The liquidator may, by virtue of office, do the following. S-386-1A, D. Execute deeds, receipts, and other documents in the company's name, using the company's seal. Prove claims in a debtor's estate and receive payment of dividends or full amounts. Draw, accept, make, or endorse bills of exchange or promissory notes on behalf of the company. Summon a general meeting of the company or creditors for necessary authority. The liquidator also has automatic authority to take protective or administrative measures for the company's affairs and property, similar to a trustee in an insolvent estate, as 386(1)(e). Underscore. 23.8.2 Powers requiring master's consent. The liquidator may perform certain acts only with the master's consent. Termination of leases, movable or immovable property, before convening the general meeting, S386-2. Sale of movable or immovable property before the general meeting, provided a written recommendation is submitted to the master, stating reasons for an immediate sale, S386-2A, 2B. The master cannot authorize the sale unless preferential right holders consent, IBID. A court cannot override this power by authorizing a provisional liquidator to sell property in its provisional order. Turnover Holdings, Proprietary, Limited v. Safi, Proprietary, Limited 1997, 1, SA 263, T. Urgent legal proceedings may be taken to recover outstanding accounts, S 386-4A. Next page. Study Notes, Powers of the Liquidator, Continue 23.8.3 Powers requiring authority of members and creditors. Most liquidator powers require approval from creditors or members. In a court-ordered winding up, authority must be obtained from meetings of members and creditors, S 386-3. In a member's voluntary winding up, authority comes from members' meetings, IBID. In a creditor's voluntary winding up, authority comes from creditors' meetings, IBID. Exception. A liquidator in a voluntary winding up may seek court leave to exercise powers without first obtaining members' or creditors' consent. Gainsford and others, NNOV Hyabab 2000, 3, SA 635, W. Powers requiring authority, S 386-4A, I. A liquidator may exercise the following powers only with the authority of members and creditors. Legal actions. Institute or defend legal proceedings on behalf of the company. Compromise debts owed to the company, accept partial payment in settlement. Compromise or admit claims against the company, including unliquidated claims. Make arrangements with creditors, except where the company cannot pay debts. Submit disputes to arbitration. Business operations and contracts. Continue or discontinue any part of the company's business necessary for beneficial winding up. Enforce or abandon uncompleted contracts, if the company cannot pay debts. Terminate lease agreements. Sell company assets, movable/immovable property, via public auction, tender, or private contract, and deliver the property. Perform any act or exercise any power not expressly requiring court leave. Key case law and principles. Urgent legal proceedings for outstanding accounts may be authorized by the master. Legal action can be taken in the company's name or by liquidators in their official capacity. Gainsford and others, NNOV Tanser Transport, Proprietary, Limited 2014, 3, SA 468, SCA 474. Unauthorized sale of company assets. Court can validate such a sale to an innocent third party under S 82(8) of the Insolvency Act. Charter Developments, Proprietary, Limited, in liquidation, v. Waterkloof Marina Estates, Proprietary, Limited and another 2015, 5, SA 138, SCA 145. Company liquidators may use S 69 of the Insolvency Act to obtain a search warrant for locating and securing insolvent estate assets. Liesel Venterno and another v. Alba Screen Workers Jebu, Proprietary, Limited, 2022, Zanchk 38. July 22, 2022, Para 21, Tapir v. Hammond No and others 2005 JDR 0854, T, Para 33. Next page. Interrogation and Inquiry in Company Liquidation. 23.9 Interrogation and Inquiry. 23.9.1 Interrogation. At a creditor's meeting for a company in liquidation and unable to pay its debts, the master, presiding officer, liquidator, and any proven creditor may interrogate any director or subpoenaed person regarding the company's business, affairs, and property, S 415-1. Examinees cannot refuse to answer questions on self-incrimination grounds unless the master consults the Director of Public Prosecutions, DPP, S 415-3. Incriminating evidence from an interrogation is inadmissible in criminal proceedings against the examinee or the company, except for perjury and related offenses, S 415-5. 23.9.2 Inquiry by Master or Court. After a winding up order, the master or court may conduct an inquiry or appoint a commissioner to investigate the company's trade, dealings, affairs, or property. SS 417, 418. Reviewability. The master's decision is reviewable under S 151 of the Insolvency Act. It is not an administrative action and not subject to the Promotion of Administrative Justice Act 3 of 2000, Nedbank Limited v. Master of the High Court, Witwatersrand Local Division 2009, 3, SA 403, W, 412, 416. Summons for inquiry. Directors, officers, persons possessing company property, debtors, or anyone with relevant information may be summoned. S 417-1. The master must properly evaluate requests to summon non-directors and should not rubber stamp requests from liquidators or attorneys. Mantis Investment Holdings, Proprietary, Limited v. Eastern Cape Development Corporation 2018, 4, SA 439, SCA, 441-2. Fairness in inquiry. The presiding officer must apply natural justice principles, ensuring procedural fairness and impartiality. Absa Bank Limited v. Hoberman 1998, 2, SA 781, C, 796, Leach v. Farber No 2000, 2, SA 444, W, 449-50. The inquiry must not be oppressive, vexatious, or unfair. Latigan v. Latigan No 2003, 6, SA 611, D, 621. A constitutional balance must be struck between investigation necessity and individual rights. Swart v. Forey, 2017, Zochk 58, May 22, 2017, Paris 24-6. Purpose. The inquiry aims to determine Companies Act violations or criminal offenses, identify grounds for director disqualification, establish companies' assets and liabilities. Bernstein v. Bester 1996, 2, SA 751, CC, 765-6. If a liquidator gains an advantage from witness testimony, it is not considered abuse if the inquiry has a valid underlying purpose. Roering No v. Malang 2016, 5, SA 455, SCA, 471. Privacy concerns are secondary to document relevance. Gamete v. Sabel No 2006, 3, SA 498, SCA, 504-5. Ulterior motives of a requesting creditor do not justify setting aside the Commissioner's decision if there are reasonable grounds for document relevance. Idem 507-8. Conduct of inquiry. The master or commissioner controls the inquiry, but liquidators, creditors, members, and contributories may interrogate witnesses. S 418-1c. The presiding officer is not required to provide a list of interrogation topics. Latigan v. Latigan No 623-5. Examinees have no right to disclosure of questioner's information before answering questions. Leach v. Farber No 449-53. A pending criminal trial does not exempt an examinee from answering questions. Mitchell v. Hodes No. Self-incrimination and compulsion. Examinees must answer, even if the response is self-incriminating. If an examinee refuses, the master or court, after consulting the DPP, may compel an answer. S 417-2b. Incriminating evidence is inadmissible in criminal trials, except for perjury and related offenses. S 417-2c. Ferreira v. Levin No 1996, 1, BCLR 1, CC, 94-5. Limitations. No inquiry under S 417 in a voluntary winding up, except if converted to court-ordered winding up, S 346-1e, or the court grants leave under S 388, Michelin Tire Company, South Africa, v. Janse van Rensburg 2002, 5, SA 239, SCA, 242. Inquiry only applies to companies unable to pay debts. If liquidation was ordered on a just and equitable basis, S 417 applies only if insolvency is later proven. Hudson v. The Master 2002, 1, SA 862, T, 868. Underscore. 23.10 Impeachable transactions. S 341. In a company liquidation, any property disposition can be set aside if it would have been voidable under insolvency law if made by an individual. Application of insolvency law. Insolvency provisions apply mutatis mutandis, with necessary changes. Key condition. The company must be insolvent at the time the liquidator or creditor invokes S341, Saxton Novi Proudfoot SA 2006, 6, SA 358, SCA, 361-2. Next page. Summary of key points on liquidation and deregistration of companies. 23.11 Release of liquidator. After fulfilling duties and meeting the master's requirements, a liquidator receives a certificate. The master consents to the reduction or cancellation of the liquidator's security, S385. 23.12 Personal liability and offenses. The court may investigate a company's promoters, directors, or officers for breach of faith, misapplied funds, or fraudulent business conduct, S423-1. The court can order repayment of misapplied assets or hold responsible persons personally liable for debts incurred through reckless or fraudulent business operations, S424-1. Key aspects of Section 424. Applies only to companies in winding up, SCH 5, Item 9(1) of the 2008 Act. Court considers the company's financial state, director roles, and debt amounts when assessing reckless trading. Philatex v. Snyman 1998, 2, SA 138, SCA. Trading while insolvent is not automatically reckless. Osinski Noviloid 1995, 2, SA 915, A. A person is knowing if the understood facts indicating reckless or fraudulent business conduct. Howard v. Harrigal 1991, 2, SA 660, A. A director may be liable even if they took no direct steps in the company's operations. Howard v. Harrigal, Supra. Independent third parties are not liable unless they actively participated in the reckless conduct. Cooper v. SA Mutual Life Assurance Society 2001, 1, SA 967, SCA. No causal link is needed between reckless conduct and debts for liability. Timing of conduct matters. Saintsik v. Industro Clean 2009, 1, SA 538, SCA. Chung v. Industrial Development Corp 2013, 3, SA 468, SCA. Creditors' rights under S424 survive unless the winding up is terminated through compromise. Kalinko v. Nisby 2002, 5, SA 766, W. Personal liability proceedings can be brought in the liquidator's or company's name. Funds Trust v. Murray 1996, 3, All SA 574, C. Default judgment cannot be used to declare liability. Minar v. Van Rooyen No 2016, 1, SA 117, SCA. 23.13 Staying or setting aside winding up proceedings. Court can stay or set aside winding up on application by a liquidator, creditor, or member, S354-1. Basis for an order. The winding up order was improperly granted. Supervening events justify staying or setting aside proceedings. Ward v. Smith 1998, 3, SA 175, SCA. The applicant bears the ordinary civil onus of proof. Ex parte strip mining 1999, 1, SA 1086, SCA. Court may consider creditor and member wishes, but evidence must show they applied their minds. SA Distributors v. Sport and Spell 1973, 3, SA 371, C. Vague letters or unsupported claims are insufficient. Porter Strat 69 I and Dom VP Eventer Worcester 2000, 4, SA 598, C. Court may intervene in voluntary winding up and give directions, S354-1. 23.14 Dissolution and deregistration. Deregistration, removal of a company's name from the register, S83-1, leading to dissolution unless transferring to a foreign jurisdiction. Dissolution occurs when winding up is complete, certified by the master, and recorded by the Commission, S82-1 and 2. Section 419 of the 1973 Act still applies, requiring publication of dissolution in the Gazette. Solvent Companies, 2008 Act prevails over 1973 Act. Insolvent companies, unclear conflict resolution between the acts. After dissolution, the company ceases to exist. Any untransferred assets revert to the state as bona vacantia. Rainbow Diamonds v. SA National Life Assurance 1984, 3, SA 1. A. Commission maintains a register of directors of dissolved companies that could not pay debts, S421. A company may be deregistered if it has ceased operations and lacks sufficient assets for liquidation, S82-3B, 2. Next page. Here's a detailed summary of Chapter 24, Winding up of close corporations from your provided text. _ Chapter 24, Winding up of close corporations. General overview. The Close Corporations Act 69 of 1984 governs winding up but incorporates provisions from the Companies Acts of 1973 and 2008. S66(1) applies Chapter 14 of the 1973 Companies Act to close corporations unless otherwise specified. Winding up must follow the 1973 Companies Act. S67(2). Terminology adjustments are outlined in S66(2) when applying the Companies Act and Insolvency Act. Close corporations may be voluntarily wound up or compulsorily wound up by a court. A close corporation can enter business rescue or conclude a statutory compromise with creditors. S66(1)(a). A composition, S72, may be entered into once liquidation has begun. _ 24.1 Voluntary winding up requires a unanimous written resolution of all members, S66(2)(bi). The Companies Acts of 2008 and 1973 apply with necessary contextual modifications. 3 types. Creditors voluntary winding up, insolvent corporation. Members voluntary winding up, solvent corporation. Voluntary winding up by the corporation. _ 24.2 Winding up by court. 24.2.1 Jurisdiction of court. Both high courts and magistrates' courts have jurisdiction, SS7 and 66(2)(a). 14. Jurisdiction is determined by the location of the corporation's registered office or a principal place of business, S7. 24.2.2 When a corporation may be wound up by court. Grounds for winding up mirror those of companies, see 23.2.2 to 23.2.4. S69 defines inability to pay debts for purposes of S68C. But S68 has been repealed, creating uncertainty. Courts consider both. S69 of the Close Corporations Act. S345 of the 1973 Companies Act, which is referenced in S344F. Case law. Scania Finance Southern Africa, Proprietary, Limited v. Tommy G. Road Carriers CC 2013, 2, SA 439. FB. Body Corporate Santa Fe Sectional Title Scheme No. 61 1994 v. Basonia 407 CC 2018, 3, SA 451, GJ. _ 24.3 Appointment of Liquidator. Master of the High Court appoints a liquidator as soon as practicable after a provisional winding up order is granted. A resolution for voluntary winding up is registered, S74(1), 2. Members voluntary winding up. The master considers the corporation's nominee, S74(3). Other cases. The master has broad discretion in appointments. Master may refuse to appoint a nominee if improper nomination, disqualification, failure to provide security for due performance, S76(1). Disputes. Aggrieved parties can request reasons from the master and escalate the matter to the minister. S66 read with S371 of the Companies Act 61 of 1973. Scheduled B. The Master and Others 2005, 4, SA 460, C. Co-liquidators. Can be appointed if nominated at the first meeting of creditors and provides security, S74-4. Spence B. The Master and Others 2000, 2, SA 717, T. Creditors must first vote on whether a co-liquidator is needed. _ 24.4 Meetings of creditors and members. Within 1 month of a final winding up order or creditor's voluntary winding up resolution, the liquidator, not the master, must summon creditors meeting, S78(1)(a). Consider the corporation's statement of affairs. Prove claims against the estate. Decide on appointing a co-liquidator. Provide directions for liquidation. Members meeting, S78(1)(b). Review corporation's affairs. Guide the liquidator on liquidation matters. DeWitt v. Boathaven CC, King and Another Intervening, 1989, 1, SA 606, C, 615, clarifies meeting requirements. _ 24.5 Liquidators report to creditors and members. Due within 3 months of appointment, except in a member's voluntary winding up. Must cover, S79. Estimated assets and liabilities. Causes of failure, if applicable. Possible offenses committed by members. Member liability for breach of trust or negligence. Repayment obligations to the corporation or creditors. See 24.6. Ongoing or pending legal proceedings. Need for further inquiry into formation, failure, or business conduct. Accounting records compliance, S56. Progress and future prospects of the winding up. Any other relevant matters. _ This structured summary includes legislation, case law, and procedural requirements while keeping the content detailed and focused. Let me know if you need further refinements. Next page. Study notes, winding up of close corporations, payments and dissolution. 24.6 Setting aside of payments to members. In a corporation's winding up, members may be required to repay money received before liquidation. If debts remain unpaid, former members may also contribute. 24.6.1 Payments by reason of membership. Members must repay payments received within 2 years before winding up unless they prove corporation's assets exceeded liabilities after the payment. Corporation could pay debts in the normal course of business. Payment did not render the corporation unable to pay debts. S72. Former members within 2 years must contribute if existing members' repayments and assets cannot cover debts. S73. Master's certificate confirming payable amounts acts as a civil judgment for execution. S74. 24.6.2 Salary or remuneration. Members may be required to return salaries/remuneration received as officers/employees within 2 years before winding up. S71(1). The master assesses whether the payment was bona fide and reasonable. If not, repayment is ordered. IBID. Former members may also be liable to contribute. S71(2). Master's certificate confirming liability acts as a civil judgment. S71(3). 24.6.3 Liquidator's duty to investigate personal liability of members. Liquidator must determine whether members are liable for repayments. Master should order repayments. S80A. B. Steps must be taken to enforce repayments. S80C. Liquidator must also establish whether any person is personally liable under Part 8 of the Act. S63. Joint liability for debts. S64. Liability for reckless or fraudulent business conduct. S65. Court's power to address abuse of separate juristic personality. If liability exists, liquidator informs creditors, and any recovered amounts affect dividends payable. S81(1). 24.7 Misapplication of money or property. Similar to S423(1) of the Companies Act, C 23.12, remedy applies to current/former members, officers/accounting officers, persons involved in forming the corporation. Court may order the person to repay or restore misapplied/retained funds or property, contribute to corporation's assets as damages. S73(1). Remedy applies even if the person is criminally liable. S73(2). 24.8 Composition, settlement agreement and liquidation. Any person can submit a written composition offer to the liquidator after liquidation begins. S72(1). If liquidator deems it likely to be accepted, it is circulated to creditors and the master. S72(2). If liquidator deems it unlikely to be accepted, the offeror may appeal to the master, who can direct circulation. S72(3). 4. Creditors consider the offer at a general meeting, publicized only after a final winding up order. S72(5). 6. Once accepted, the composition binds all creditors who had notice and voting rights, provided 2/3, by number and value, of creditors approve. Payment is secured as per the offer. Secured/prefer creditors' rights are unaffected unless waived in writing. S72(7). Prohibited provisions. No extra benefit for any creditor beyond ordinary estate distribution. S72(7)(a). Surety liability remains unaffected. S72(8). Liquidator handles all payments and distributions. S72(9). 10. Composition may allow for setting aside the winding up via court order. S72(11). Creditors/others may oppose the composition based on unfair prejudice to creditor interests, material irregularities in meetings, insufficient or false information, other court-determined grounds. S72(12). 24.9 Dissolution and deregistration of corporation. Deregistration and dissolution provisions of Companies Act 2008 apply to closed corporations. S26 of Closed Corporations Act. Relevant Companies Act sections. S81(1)(f), 81(3), Dissolution procedures. S82(3), 4, 83, Deregistration process, C 23.14. Next page. Chapter 25 The commencement of business rescue proceedings. 25.1 The nature and purpose of business rescue proceedings. Purpose: To rehabilitate a financially distressed company through temporary protection from creditors. Business Rescue Practitioner, BRP, an independent expert appointed to manage the process and propose a rescue plan. Legislative basis. Chapter 6 of the Companies Act 71 of 2008 applies to companies and close corporations under S66(1)(a) of the Close Corporations Act 69 of 1984. Regulatory difference. Winding up, supervised by the Master of the High Court. Business Rescue, supervised by the Companies and Intellectual Property Commission, CIPC. Exclusions. External companies, foreign incorporated companies not registered in SA, cannot enter business rescue, Cooperativa Moratoria Cementisti and others v. SIPC and others 2021, 3, SA 393, SCA, 396-7. Key principles of business rescue. Legislative preference. Business rescue is preferred over liquidation if the company has a reasonable chance of recovery. Ferrostal GmbH v Transnet Soak Limited 2021, 5, SA 493, SCA, 503. Balancing stakeholder interests. Unlike liquidation, creditor-focused, business rescue considers creditors, shareholders, and employees. Oakdean GSJ 278-9, Boysen v Jonkir Boruin Makery 2017, 4, SA 51, WCC, 59. Preservation of business, not entity. Rescue can involve selling parts of the business rather than saving the company itself. Oakdean SCA 551, next page. Study notes. The commencement of business rescue proceedings. 25.1 The nature and purpose of business rescue proceedings. Purpose: rehabilitation of financially distressed companies through temporary protection from creditors. Process: managed by an independent business rescue practitioner, BRP, who formulates a rescue plan. Legislative basis. Chapter 6 of the Companies Act 71 of 2008 also applies to closed corporations under S66(1)(a) of the Close Corporations Act 69 of 1984. Regulatory oversight. Business rescue, supervised by the Companies and Intellectual Property Commission, CIPC. Liquidation, regulated by the Master of the High Court. Exclusions. External companies cannot enter business rescue, Cooperativa Moratoria Cementisti and others v. SIPC and others 2021, 3, SA 393, SCA, 396-7. Balancing interests. Unlike liquidation, creditor prioritized, business rescue considers creditors, shareholders, and employees. Oakdean GSJ 278-9, Boysen v Jonkir Boruin Makery 2017, 4, SA 51, WCC, 59. Legislative preference. Courts favor business rescue over liquidation if a viable recovery plan exists. Ferrostal GmbH v Transnet Soak Limited 2021, 5, SA 493, SCA, 503, DH Brothers Industries v Gribnitz No 2014, 1, SA 103, KCP, 108-9. Business continuity, not entity preservation. Parts of the business may be transferred to another entity. Oakdean SCA 551. Judicial scrutiny on abuse. Courts prevent abuse where a company seeks to evade creditors. Swart v Beagles Run Investments 2011, 5, SA 422, GNP, 429. Business rescue is used to block liquidation. ABSA Bank v New City Group 2013, 3, All SA 146, GSJ. 16-17. Proceedings are initiated for companies with no viable recovery prospects. Vandermeer v Zonagas Mansion 2017 JDR 0023, WCC, Paris 96-104. 25.2 Substantive requirements for the commencement of business rescue proceedings. 25.2.1 Financial distress and alternative financial criteria. Financial distress definition, S128(1)(f). A company is financially distressed if it is unlikely to pay debts as they become due in the next 6 months. Its liabilities exceed assets within the next 6 months. Alternative criteria. Even if not financially distressed, business rescue may be initiated if it prevents potential liquidation or enhances creditor recoveries. Oakdean SCA 550. 25.2.2 Reasonable prospect of rescuing the company. A court must be convinced of a reasonable prospect of success, requiring more than a speculative or vague assertion. Southern Palace Investments 265 v Midnight Storm Investments 386, 2012, 2. SA 423, WCC 426. Judicial precedents on reasonable prospect. A well-grounded and factual basis for financial recovery must exist. Oakdean SCA 552. Business rescue should not be a delay tactic. Vandermeer v. Zonicus Mansion, Supra, Paris 56-58. 25.3 The commencement of business rescue proceedings. 25.3.1 Voluntary business rescue, Director's Resolution, S-129. The Board may resolve to enter business rescue if the company is financially distressed. Requirements. File resolution with SIPC within 5 business days. Appoint a BRP within 5 business days after resolution filing. Publish a notice of resolution and BRP appointment to affected persons. Setting aside resolution, S-130. Affected persons, creditors, shareholders, employees, may apply to court for cancellation if the company was not actually financially distressed. No reasonable prospect of success exists. Business rescue was commenced in bad faith. Standard Bank v. C&E Engineering, 2020, Zank JHC 255 Paris 59-64. 25.3.2 Compulsory business rescue, court application, S-131. Any affected person, creditor, shareholder, trade union, may apply for business rescue. Requirements. The company must be financially distressed, or business rescue would be in the interest of creditors/employees. Court considerations. A reasonable prospect of rescue must exist. Shiva Uranium, Proprietary, Limited v. Taub 2022, 3, SA 432, CC, 442. Business rescue should not merely be used to delay liquidation. ABSA Bank v. New City Group, Supra. 25.3.3 Duration of business rescue proceedings, S-132. Proceedings should last 3 months unless extended by court approval. Termination. If the BRP files a notice that the company is no longer distressed. If a rescue plan is rejected and no alternative is proposed. If the court sets aside the process. Key case law references. Ferrostyle GmbH v Transnet Soak Limited 2021, 5, SA 493, SCA. Preference for business rescue over liquidation. Oakdean SCA 551. Business rescue is about preserving business operations, not necessarily the entity itself. Southern Palace Investments v Midnight Storm Investments 2012, 2, SA 423, WCC 426. Reasonable prospect requires a factual basis, not mere speculation. Swart v Beagles Run Investments 2011, 5, SA 422. GNP, 429. Courts monitor abuse of business rescue proceedings to delay creditor action. ABSA Bank v New City Group 2013, 3, All SA 146, GSJ, 16-17. Business rescue should not be used to block liquidation. Vandermeer v Zonicus Mansion 2017 JDR 0023, WCC, Paris 96-104. Courts may reject friendly business rescue applications with no recovery prospects. This summary provides a structured overview of the key principles, legislative framework, and case law regarding the commencement of business rescue proceedings. Study notes, substantive requirements for the commencement of business rescue proceedings. 25.2 Substantive requirements for business rescue. To qualify for business rescue, a company must satisfy 2 criteria. Financial distress or alternative financial criteria, SS 129, 131. Reasonable prospect of rescuing the company. 25.2.1 Financial distress and alternative financial criteria. Primary requirement, financial distress as per S 128. Voluntary business rescue, S 129, always requires financial distress. Compulsory business rescue, S 131. Either financial distress, or one of the 2 alternative financial criteria in S-131. Significance of financial distress. Many provisions assume financial distress is necessary. S-141-2b. The business rescue practitioner, BRP, must terminate proceedings if the company is no longer financially distressed. Financial distress, S-128-1f. A company is financially distressed if it is reasonably unlikely to pay debts as they become due within the next 6 months. It is reasonably likely to become insolvent within the next 6 months. Case law interpretations. Narrow interpretation, Gormley v West City Precinct Properties 2013 JDR 1895, WCC, Merchant West Working Capital Solutions v Advanced Technologies 2013 JDR 1019, GSJ. A company that is already insolvent but able to pay debts over time is not financially distressed. Broader interpretation, Oakdean SCA 543, Tire Corporation Cape Town VGT Logistics 2017, 3, SA 74, WCC, 79. A company that is commercially or factually insolvent may still qualify for business rescue. 2. Failure to pay employment-related amounts, S131 4A, 2. A company qualifies for business rescue if it has failed to pay employee salaries, employment-related obligations, for example, withheld tax, unemployment insurance. Significance, often an early indicator of financial distress. Applicants. This ground is particularly useful for trade unions and employees. Any affected person, S131-1, may rely on it. Judicial discretion. Courts assess the circumstances of non-payment before granting business rescue. 3. Other financial reasons making business rescue just and equitable, S131-4A. 3. Courts may order business rescue if it is just and equitable for financial reasons. Wide judicial discretion. Tire Corporation Cape Town VGT Logistics, Supra, 80. Covers financial difficulties beyond strict financial distress. Otherwise just and equitable suggests the difficulties must be of a similar nature to financial distress. Potential consideration of affected persons, Oakdean GSJ 281. Courts may consider the financial situation of creditors, employees, or other stakeholders. These provisions ensure that business rescue remains accessible not only to companies on the brink of financial collapse but also to those experiencing financial instability in ways that may justify intervention. Next page. Study notes, reasonable prospect of rescuing the company. 25.2.2 Reasonable prospect of rescuing the company. A business rescue application requires a reasonable prospect that the company can be rescued, S131-4A. This requirement applies throughout the business rescue process. Business rescue practitioner, BRP, must assess it after investigating the company's affairs, S141-1. Reported at first meetings of creditors, S147, and employees, S148. Reassessed at the meeting to vote on the business rescue plan, S152. If, at any stage, the BRP concludes that rescue is not possible, they must inform the court, the company, and affected persons. Apply to terminate business rescue and place the company in liquidation, S141-2A. Underscore I. Meaning of rescue. Definition in S128-1 HSV. Rescuing the company. Primary goal, restore the company to a solvent going concern. Secondary goal, if primary goal is unattainable, business rescue must result in a better return for creditors/shareholders than immediate liquidation, S128-1B. Methods of achieving business rescue. Temporary supervision of the company's management. Temporary moratorium on claims against the company. Development of a business rescue plan, involving restructuring of business affairs, property, debt and other liabilities, equity. Case law on the goals of business rescue. Conflicting interpretations on the secondary goal. Allowed, business rescue proceedings can be used to achieve a better return, even if solvency is unattainable. Swart v. Beagles Run Investments 2011, 5, SA 422, GNP, 431. Southern Palace Investments 265 v. Midnight Storm Investments 2012, 2, SA 423, WCC, 432. Kuhn v. Witchwood Village Golf and Country Estate 2012, 2, SA 378, WCC, 384. Oakdean GSJ 289. Not allowed, business rescue should be used only for rehabilitation, and the secondary goal applies only during proceedings. AG Petsetakis International Holdings v. Petsetakis Africa 2012, 5, SA 515, GSJ, 521-2. Gormley v. West City Precinct Properties 2013 JDR 1895, WCC, Para 12. Kovacs Investments 571 v. Investec Bank, 2012, Zochk 110 Paras 17, 19. Final position, Supreme Court of Appeal, SCA. Oakdean SCA 549-51. Both primary and secondary goals are valid standalone justifications for business rescue. Business rescue provides temporary protection to facilitate an optimal return for creditors through an orderly sale. Hockly SCA 551. 2. Reasonable prospect of rescue. Definition of prospect: an expectation that one of two uncertain events will occur. 1. Company recovery, primary goal. 2. Better return than immediate liquidation, secondary goal. PropSpec Investments v Pacific Coast Investments 2013, 1, SA 542, FSB, 545. ABSA Bank v New City Group 2013, 3, All SA 146, GSJ, Para 14. Standard of proof. A reasonable prospect is lower than reasonable probability, Hockly SCA 551-2, but it requires more than mere speculation. PropSpec Investments, Supra, 545. Application papers must establish a factual basis that supports achieving either rescue goal. Hockly SCA 551. Factors considered by the court. No strict list of required particulars. Hockly SCA 552. The level of detail required depends on circumstances. PropSpec Investments, Supra, 546. Courts should not impose an excessive evidentiary burden. PropSpec Investments, Supra, 546. Information available to the applicant is a relevant factor. Solar Spectrum Trading VF3, 2012, Zuck page C 359 paras 16-17. Negative inference may be drawn if the company fails to address key issues in opposing an application. Ziegler SAV SA Express 2020, 4, SA 626. GJ, Para 63. Primary goal considerations. Business rescue must restore the company as a solvent, going concern. Hockly SCA 555-6. Not enough to show factual solvency from selling assets. Hockly SCA 555. Relevant indicators of feasibility. Availability of post-commencement finance. Support from key suppliers and creditors. Sector-specific challenges, for example, economic downturn versus poor management. Ziegler SAV SA Express, Supra, 636. Secondary goal considerations. A better return than immediate liquidation must be demonstrated. Liquidation comparator is critical. Reliable valuation of assets and liabilities. Tire Corporation Cape Town VGT Logistics 2017, 3, SA 74, WCC, 78-9, 81-2. Projected income streams under business rescue. Hockly SCA 554-5. Cost of liquidation versus business rescue. New City Group v Pelono, 2014, Zaska 162 Para 21. A fire sale assumption is not automatic in liquidation. Tire Corporation Cape Town VGT Logistics, Supra, 82. Policy considerations. Business rescue should not be used as an informal liquidation process. Hockly SCA 553. The legislature did not intend to introduce business rescue just to save on liquidation costs. Hockly SCA 553. Key takeaways. A reasonable prospect is required throughout business rescue proceedings. The primary goal is to restore solvency, but the secondary goal of achieving a better return is now a standalone justification. Hockly SCA. Courts require more than speculation, but not absolute certainty that rescue will succeed. A liquidation comparison must be factually supported when relying on the secondary goal. Next page. Hockly SCA. Key judgment on business rescue. Significance of Hockly SCA. First Supreme Court of Appeal, SCA. Decision on business rescue clarified that ensuring a better return for creditors/shareholders can be an independent goal. Provided guidance on integrating Chapter 6 business rescue into commercial practice. Case background. Appeal against dismissal of business rescue application and granting of liquidation order. Initial purpose: prevent sale and execution of two fixed properties, including the Kyalami Racing Complex. By the time of appeal, liquidation had already commenced. Appellants argued business rescue would yield a better return than liquidation. Appellants included a 40% shareholder, two opposing shareholders included a major creditor holding a mortgage bond. Companies' legal disputes. Disputed agreements involving directors' associated entities. Validity of an unprofitable lease. Eviction of the current occupier under an allegedly invalid cession. Attempted sale of the company's development rights. Alleged cession of the company's income stream. Legal arguments. Appellants, only needed to show that a business rescue plan could be developed and implemented. Respondents, business rescue required a reasonable prospect of restoring solvency. Court's view. Business rescue means achieving either 1. Returning the company to solvency. 2. Providing a better return than liquidation. Definitions in S-128-1B override dictionary meanings of rescue and rehabilitation. Standard for establishing a reasonable prospect. More than a prima facie case is required. Must provide some factual basis for success. A mere speculative plan is insufficient. Motion proceedings, though not ideal, apply under the Companies Act. Courts must assess business rescue on reasonable grounds. Court's findings. Rejected appellant's argument that business rescue should be granted simply because a plan could be developed. Confirmed that rescue requires achieving a goal in S-128-1B. Developing a plan alone is insufficient. Appellant's proposals lacked factual support. No clear basis for claiming a higher sale price in business rescue than in liquidation. Assumption that a business rescue practitioner's costs would be lower than a liquidator's was unsubstantiated. Overlooked complications from disputes and uncertain transactions. Selling 2 properties and retaining one was flawed. Ignored an owner as lease and lost development rights. Even if properties were sold, entire income stream was ceded, leaving no revenue to service debts. Final considerations. Selling all assets does not constitute restoring a company to solvency. If liquidation with a cash surplus equaled business rescue, every insolvent but factually solvent company would qualify. Solvency means continuing as a going concern. Major creditors' intent to oppose business rescue was a key factor. If the creditor voted against the plan, it would fail unless court intervention occurred. Guidance for future cases. Established criteria for assessing reasonable prospects of business rescue. Provided direction on when liquidation is preferable. This judgment set a crucial precedent for business rescue applications, reinforcing that courts require clear, factual evidence of a viable business rescue prospect. Next page. Commencement of business rescue proceedings. 1. Business rescue initiation. Business rescue proceedings may begin through voluntary business rescue, a resolution adopted by the company's board. Compulsory business rescue, a court order. 2. Voluntary business rescue. Board resolution. The board may initiate business rescue if the company is financially distressed. There is a reasonable prospect of rescuing it, S-129-1A. B. The resolution is ineffective until filed with the Commission, S-129-2B. Form Core 123.1, SIP Practice Note 1 of 2020. The board must act in good faith. Grease Cell Vialize More 2016, 6, SA 236, GJ, Standard Bank VC&E Engineering, 2020, ZAG HC 255. A company cannot adopt a voluntary business rescue resolution if liquidation proceedings have been initiated, S-129-2A. Liquid. Next page. Commencement of business rescue proceedings. Business rescue proceedings can be initiated through voluntary business rescue, resolution by the Board of Directors. Compulsory business rescue, court order. 25.3.1 Voluntary business rescue. Board resolution. The board may resolve. Next page. Here's a structured summary of the provided text. 25.3 The commencement of business rescue proceedings. Business rescue can be initiated through voluntary business rescue, board resolution, compulsory business rescue, court order. 25.3.1 Voluntary business rescue. Board resolution. The Board of Directors may adopt a resolution for voluntary business rescue if the company is financially distressed. There is a reasonable prospect of rescuing the company, S-129-1A. B. The resolution takes effect only upon filing with the Commission, S-129-2B. Board must act in good faith when adopting the resolution. Grease Cell and Another Vialize More and Others 2016, 6, SA 236, GJ, Standard Bank of South Africa Limited VC&E Engineering, Proprietary, Limited and Others, 2020, ZAG HC 255. Liquidation proceedings bar business rescue. If liquidation has been initiated, business rescue cannot proceed, S-129-2A. Liquidation is initiated when the court application is served on the company, Chica Training Matters, Proprietary, Limited VKPPM Construction, Proprietary, Limited and others 2019, 6, SA 185, GJ. Exception, in Mooden v. Park 2000 Development 11, Proprietary, Limited and others 2019, 6, SA 105, WCC. The court held liquidation is initiated when a resolution to apply for liquidation is adopted, but this approach is criticized as unworkable. Compulsory business rescue may still be granted by the court even if liquidation proceedings are underway. First Trend Bank Limited v. Imperial Crown Trading 143, Proprietary, Limited 2012, 4, SA 266, KZD. If a business rescue resolution is adopted, the company cannot later resolve to liquidate itself during the rescue process, S 129-6. If the board does not adopt a resolution despite financial distress, it must notify affected persons, S 129-7. 2. Formalities after adoption of the resolution. Within 5 business days of filing the resolution, the company must publish a notice of the resolution and its effective date to affected persons. Provide a sworn statement on the reasons for business rescue. Appoint a business rescue practitioner, S 129-3A, B. Within 2 business days after appointing the practitioner, the company must file a notice of appointment. Within 5 business days after filing, a copy of the appointment notice must be published to affected persons, S 129-4A. B. Substantial compliance is sufficient, ex parte Van den Steen No and others 2014, 6, SA 29, GJ. Failure to comply with appointment, filing, or notice requirements results in the resolution lapsing and becoming void, S 129-5A. The court may set aside business rescue but it does not erase prior rescue steps. Panama Properties, Proprietary, Limited and another VNL and others NNO 2015, 5, SA 63, SCA. The company is barred from filing another resolution for 3 months, unless the court allows otherwise, S 129-5B. 3. Right of affected persons to object. Affected persons may apply to set aside the resolution if, S 131A. The company is not financially distressed. There is no reasonable prospect of rescue. The company failed to comply with procedural requirements. Court may grant the application if just and equitable, S 135A. Supreme Court of Appeal ruling. The term or in S 135A must be read as and, Panama Properties, Proprietary, Limited VNL and others NNO, Supra. Affected persons include, S 128-1A. Shareholders. Creditors. Registered trade unions representing employees. Employees, if not union represented, directors who voted for the resolution cannot apply unless they prove they acted in good faith based on misleading information, S 132. Application must be filed before a business rescue plan is adopted, S 131A. The applicant must serve a copy on the company and the commission. Notify all affected persons, S 133. Affected persons may participate in the hearing, S 134. Court's discretionary powers may require a report from the business rescue practitioner on financial distress, S 135B. May issue liquidation orders or cost orders against directors who acted irresponsibly, S 135C. Can validate enforcement action taken by creditors unaware of business rescue, Aldebaran, Proprietary, Limited and another V-Bauer and others 2018, 5, SA 215, WCC. Assessment of reasonable prospect of rescue. Courts apply the same standard in voluntary and compulsory business rescue cases. Finance Factors CCBJSM, Proprietary, Limited 2013 JDR 1901, KZD. The applicant must show that at the time of the hearing, no reasonable prospect of rescue exists. If a business rescue plan has been proposed, it must be shown as unviable. Just an equitable consideration. Courts evaluate if the resolution was adopted for a proper purpose. Standard Bank of South Africa Limited VC&E Engineering, Proprietary, Limited and others, Supra. _ This summary preserves all essential legislative provisions, case law, and procedural rules, while maintaining conciseness and clarity. Let me know if you need further refinements. Next page. Here's a structured summary of the section on compulsory business rescue applications. _ 25.3.2 Compulsory Business Rescue, Court Application I. The application. An affected person may apply to court for an order placing a company under business rescue, S-131-1. The High Court with jurisdiction or a designated commercial judge will hear the application, S-128-1E. The application is permitted at any time, unless the company has already adopted a voluntary business rescue resolution, S-131-1. An application may still be brought even if liquidation proceedings have commenced, S-131-6. Liquidation proceedings refer to the process of realizing assets and accounting to creditors, not just the liquidation application. Richter v. ABSA Bank Limited 2015, 5, SA 57, SCA. Dormancy of business can affect prospects of rescue. Vendor Merva and others v. Zonicus Mansion, Proprietary, Limited, in liquidation, 2016, Zochk 193. 2. Preliminary formalities. The applicant must serve a copy of the application on the company, the Companies and Intellectual Property Commission, CIPC, each affected person, S-131-2. Regulation 124 requires that affected persons receive a copy of the application, not just a notification. Cape Point Vineyards, Proprietary, Limited v. Pinnacle Point Group Limited 2011, 5, SA 600, WCC. Affected persons have the right to participate in the hearing, S-131-3. 3. Application suspends liquidation proceedings. If liquidation proceedings are already underway, the business rescue application suspends them until the court dismisses the application or business rescue concludes, S-131-6. The application is considered made once it is served on all required parties. Standard Bank of South Africa Limited v. Gas 2 Liquids, Proprietary, Limited 2017, 2, SA 56, GJ. Clarification of liquidation proceedings. Suspension applies only to actions of the master and liquidator in realizing assets. GCC Engineering, Proprietary, Limited v. Maroos 2019, 2, SA 379, SCA. Directors do not regain control over assets. Uncertainty regarding pending winding-up applications. Some courts held that a winding-up order can still be granted despite business rescue applications. ABSA Bank Limited v. Summer Lodge 2013, 5, SA 444. GNP. However, in Goro Consortium, Proprietary, Limited v. Cedar Park Properties 39, Proprietary, Limited 2022 JDR 1108, SCA, the court indicated that liquidation proceedings must be removed from the roll once a business rescue application is lodged. 4. Discretion of the court. The court may grant a business rescue order if the company is financially distressed. The company has failed to pay employment-related obligations. It is just and equitable to do so for financial reasons. There is a reasonable prospect of rescuing the company, S-131-4. A court may initiate business rescue on its own during liquidation proceedings or enforcement of security, S-131-7. Balancing policy considerations. Courts must weigh factors based on policy and value judgments. New City Group, Proprietary, Limited v. Pelono, 2014, Zaska 162. Factors weighing against business rescue. The company has no employees or very few. First Rand Bank Limited v. Normandy Restaurants Investments 2016 JDR 2212, SCA. Rehabilitation is expected to take too long. Shiva Uranium, Proprietary, Limited v. Taub 2022, 3, SA 432, CC. Unfair treatment of creditors under the plan. Tire Corporation Cape Town, Proprietary, Limited v. GT Logistics, Proprietary, Limited 2017, 3, SA 74, WCC. Ongoing legal disputes diverting attention from rescue, Oakdean SCA 554. Presence of onerous contracts or questionable transactions, Oakdean SCA 554. Lack of support from affected persons, Tire Corporation Cape Town, Proprietary, Limited v. GT Logistics, Proprietary, Limited. Directors benefiting at the expense of creditors, DH Brothers Industries, Proprietary, Limited v. Gribnitz No 2014, 1, SA 103, KZP. If the order is granted, the court may appoint an interim practitioner, nominated by the applicant, subject to creditor approval, S-131-5. If the court dismisses the application, it may issue a liquidation order, S-131-4B. V. Subsequent formalities and restriction on voluntary liquidation. The company must notify affected persons of the order within 5 business days, S-131-8B. The company cannot voluntarily liquidate itself while under business rescue, S-131-8A. Comparison with voluntary business rescue, S-129-6. S-129-6 prevents the company from applying to court for liquidation. S-131-8 prevents the company from passing a resolution for voluntary liquidation. Courts may convert business rescue into liquidation if necessary under Chapter 6 of the Companies Act 2008. This summary maintains a detailed legal focus while reducing unnecessary explanations and examples. Let me know if you need modifications. Next page. Study Notes, Business Rescue Proceedings in South Africa. 25.3.2 Compulsory Business Rescue, Court Application I, the application. Who may apply? An affected person can apply to the High Court for an order placing a company under business rescue, S-131-1. Jurisdiction, High Court with jurisdiction over the company or a designated commercial judge, S-128-1E. Timing, the application may be made at any time unless the company has adopted a voluntary business rescue resolution, S-131-1. Application during liquidation. Can be made even if liquidation proceedings have started, S-131-6. Liquidation proceedings refer to asset realization and creditor accounting, not just filing for liquidation. Richter v. Absa Bank Limited 2015, 5, SA 57, SCA. If a company has been dormant in liquidation, the likelihood of successful rescue decreases. Van der Merwe v. Zonnegut Mansion, 2016, Zoch 193. 2. Preliminary formalities. Applicant must serve a copy on the company's commission. Notify each affected person in the prescribed manner, S-131-2. Affected persons must receive a copy of the application, Regulation 124. Each affected person has the right to participate in the hearing, S-131-3. Case Law, Cape Point Vineyards, Proprietary, Limited v. Pinnacle Point Group Limited 2011, 5, SA 600, WCC, confirms that mere notification is insufficient, a copy must be provided. 3. Application suspends liquidation proceedings. If liquidation proceedings are underway, the business rescue application suspends liquidation until the court dismisses the business rescue application, or the business rescue process ends, S-131-6. Key case law. Application is made once served on all required parties, Standard Bank v. Gas 2 Liquids 2017, 2, SA 56, GJ. Suspension applies only to the master and liquidator's actions in realizing assets, GCC Engineering v. Maroos 2019, 2, SA 379, SCA. Uncertainty exists regarding pending winding up applications, Absa Bank v. Summer Lodge 2013, 5, SA 444, GNP. 4. Discretion of the court. The court may grant business rescue if the company is financially distressed. The company has failed to pay amounts due under employment-related regulations. It is just inequitable for financial reasons. There is a reasonable prospect of rescue, S-131-4. The court can place a company under business rescue on its own initiative in liquidation or security enforcement proceedings, S-131-7. Discretion involves balancing policy considerations, New Citigroup v. Pelono 2014 ZASCO 162. Factors against granting rescue. Company has few or no employees, First Rand Bank v. Normandy Restaurants 2016 JDR 2212, SCA. Business rescue will take too long, Shiva Uranium v. Teop 2022, 3, SA 432, CC. Proposed plan is unfair to creditors, Tire Corporation v. GT Logistics 2017, 3, SA 74, WCC. Company involved in ongoing litigation, Oakdean SCA 554. Company has onerous contracts that a liquidator could cancel, Oakdean SCA 554. Affected persons do not support rescue, Tire Corporation v. GT Logistics. Directors who guaranteed debts would benefit, DH Brothers Industries v. Gribnitz 2014, 1, SA 103, KZP. V. Subsequent formalities and restriction on voluntary liquidation. Notifications. Court-supervised companies must notify affected persons within 5 business days, S-131-8B. Restriction on voluntary liquidation. A company under business rescue may not place itself in liquidation until the rescue proceedings end, S-131-8A. This is similar to S-129-6, which applies to companies that voluntarily enter business rescue. Courts can still convert business rescue into liquidation under Chapter 6 of the Companies Act 2008. Underscore 25.3.3 Duration of business rescue proceedings. Commencement of business rescue. Business rescue begins when a resolution is filed by the company. The company applies for permission to file a new business rescue resolution within 3 months of a lapsed resolution, S-129-5B. An affected person applies for an order. The court orders business rescue during liquidation or security enforcement proceedings, S-132-1. Termination of business rescue. Business rescue ends when the court sets aside the resolution or order that started proceedings. The court converts business rescue into liquidation. The practitioner files a notice terminating proceedings. The business rescue plan is rejected, and no affected person acts to extend the proceedings. The business rescue plan is adopted, and the practitioner files a notice of substantial implementation, S-132-2. Next page. Business rescue proceedings and general moratorium, summary. 25.3.3 Duration of business rescue proceedings. Commencement of proceedings, S-132-1. When the company files a resolution to place itself under supervision. When the company applies to court for permission to file a second resolution within 3 months of the lapse of an earlier one. When an affected person applies to court for an order placing the company under supervision. When, during liquidation or enforcement proceedings, the court places the company under supervision. Termination of proceedings, S-132-2. The court sets aside the resolution or order. Proceedings are converted into liquidation. The business rescue practitioner files a termination notice. The business rescue plan is rejected with no action taken to extend proceedings. The business rescue plan is adopted and substantially implemented. Underscore. Chapter 26, The Effects of Business Rescue Proceedings. 26.1 General Moratorium. Restriction on legal action. No legal proceedings, including enforcement actions, may commence or proceed against the company or its property without the written consent of the business rescue practitioner. The court's leave, subject to conditions, S-133-1. Restriction on guarantee/suretyship enforcement, cannot be enforced without court approval, S-133-2. 26.1.1 Purpose and duration of the moratorium. Purpose, to provide breathing space for restructuring and prevent asset liquidation. Cleet Murray and another NNOV First Rand Bank Limited TA Westbank 2015, 3, SA 438, SCA. Scope. Applies to pre- and post-commencement claims, SA Airlink Visa, 2020, ZASCA 156. Limits third-party rights, S34 of the Constitution, but justified for business rescue. Boysen v. Jangkir Boruin Makery. Proprietary, Limited 2017, 4, SA 51, WCC. Cannot indefinitely delay claims, Ahrens v. Vandermerve NNO 2016, 6, SA 490, GJ. Abuse prevention. Business rescue used to delay enforcement does not equal abuse if creditors benefit. Nupno v. Forster No 2019 JDR 1206, GJ. Abuse occurs when proceedings are used only for moratorium protection. Standard Bank VC and E-Engineering, 2020, ZAGPJHC 255. Business Rescue Plan Extensions. A plan can extend moratorium beyond automatic protection, S-152BI. 26.1.2 Scope of the moratorium. I. Legal proceedings and enforcement action. Includes formal court and arbitration proceedings, Cleet Murray v. Westbank 2015, 3, SA 438. SCA. Covers labor court matters, Murray v. Shiva Uranium, Proprietary, Limited 2019, 40, ILJ 177, LC. Enforcement equals actions taken to execute a court order, Cleet Murray v. Westbank Supra. 2. Against the company or its property. A personal defense, Timasani v. Afrimat Iron Ore, 2021, 3 All SA 843, SCA. Does not protect third parties like sureties. Business Partners v. Zakiroglu 2016, 4, SA 390, WCC. Applies to liquidation applications, BP Southern Africa v. Intertrans Oil SA 2017, 4, SA 592, GJ. 3. Eviction and repossession proceedings. If a contract is cancelled, moratorium does not apply. Kythera Court Villa Rendezvous Cafe 2016, 6, SA 63, GJ. Applies to repossession of assets. JBJ Logistics v Standard Bank 2016, 6, SA 448, KZD. 4. Proceedings related to business rescue. Conflicting case law. Not subject to moratorium. Actions regarding business rescue implementation. Moodley v. Digital Media 2014, 6, SA 279, GJ. Subject to moratorium. Setting aside a business rescue resolution. Absavin Odno, 2014, Zuck page C 181. Moratorium applies. Applications to compel business rescue termination. Airports Company SAV Spain No 2021, 1, SA 97, KZD. Next page. Here's a detailed summary of Chapter 26, the effects of business rescue proceedings in bullet points. Underscore. 26.1 General moratorium. Legal proceedings, including enforcement action, against the company or its property may not be commenced or continued without written consent of the business rescue practitioner. S-133-1A. Leave of the court on terms it considers suitable. S-133-1B. Guarantees or suretyships by the company cannot be enforced without leave of the court. S-133-2. 26.1.1 Purpose and duration of the moratorium. The moratorium is one of the three pillars of business rescue along with temporary supervision in the Business Rescue Plan, S25.2.2I. Purpose. Provides breathing space from litigation for company restructuring. Cleet Murray and another NNOV First Rand Bank Limited TA Westbank 2015, 3, SA 438, SCA 441. Prevents asset attachment and sale and execution crucial for business operations. Nuke Novi Forster No 2019 JDR 1206, GJ, Para 14. Duration. Applies throughout business rescue proceedings. S132, 25.8.8. Covers all claims, whether pre or post commencement. SA Airlink Visa, SOC, Limited and others. 2020, Zaska 156, November 30, 2020. Paras 18 to 19. Raises constitutional concerns. S34 of the Constitution, but is justified. Boysen v Jongkir Boruin Makery, Proprietary, Limited 2017, 4, SA 51, WCC, 67. Cannot be used to indefinitely delay claims. Aarons and others v Vandermerve and another NNO 2016, 6, SA 490, GJ, 493-4. Risk of abuse to exploit protection. Standard Bank VC and E Engineering, 2020, Zang HC 255 Paras 60-65. Legitimate if creditors as a whole benefit. Nuke Novi Forster No Para 13. A business rescue plan can extend the moratorium upon approval. S152BI, S27.6.1. 26.1.2 Scope of the moratorium. I. Legal proceedings and enforcement action. Covers formal dispute resolution proceedings, court, tribunal, arbitration. Cleet Murray v First Rand Bank 2015, 3, SA 438, SCA, 445. Includes arbitration. Shetty v Hart 2015, 6, SA 424, SCA, 433-4. Covers labor court proceedings. Murray v Shiva Uranium, Proprietary, Limited, in Business Rescue, 2019 ILJ 177, LC, 182-4. Excludes. Normal, extrajudicial, contractual enforcement. Cleet Murray 445-6. Contract cancellations do not require court permission. 2. Proceedings against the company or its property. The moratorium is a personal defense. Timasani v Afrimat Iron Ore, 2021, 3 All SA 843, SCA, 853. Protects only the company, not third parties like sureties. Business Partners Limited v Zakiro Glue 2016, 4, SA 390, WCC, 394 Legal proceedings include liquidation applications. BP Southern Africa v Intertrans Oil SA 2017, 4, SA 592, GJ, 608-9. Not applicable to property not lawfully possessed by the company. Timasani v. Afrimat Iron Ore 854. Unclear whether moratorium applies to property in lawful possession but owned by third parties. 3. Eviction and repossession proceedings. If a contract is cancelled, property is no longer lawfully possessed, and moratorium does not apply. No moratorium protection for evictions from leased premises. Kythera Court Villa Rendezvous Café 2016, 6, SA 63. GJ. Repossession of goods under installment sales. JBJ Logistics v. Standard Bank 2016, 6, SA 448, KZD. 4. Proceedings related to business rescue proceedings. Conflicting case law. Moratorium does not apply to legal proceedings on how business rescue is conducted. Moodley v. Digital Media 2014, 6, SA 279, GJ. 284. Moratorium applies to challenges against the business rescue process itself. ABSA Bank v. Nodno 2014 SOG page C 181. _ 26.2 Property interests. Business rescue restricts transactions involving company property. Transactions must align with the business rescue plan and have practitioner approval. 26.3 Employment contracts. Employees retain their contracts during business rescue unless the practitioner terminates them due to operational reasons. Changes are agreed upon through negotiation with employees. Employees are treated as preferential creditors for unpaid salaries. 26.4 Other contracts. Unexecuted contracts. Business rescue does not automatically terminate contracts. The practitioner may suspend or cancel unperformed obligations. S-136-2. Counterparties' rights. Counterparties cannot enforce specific performance against the company. However, they can claim damages for breach of contract. 26.5 Shares and other securities. Business rescue freezes changes in shareholding and securities to prevent external interference. Shareholders cannot enforce rights that may disrupt the rescue process. Issuance of new shares requires practitioner approval. 26.6 Directors. Directors remain in office but their powers are limited. The business rescue practitioner assumes control of the company's management. Directors must cooperate and provide information to the practitioner. Failure to comply can lead to personal liability for reckless conduct. _ Key cases. Cleet Murray v. First Rand Bank, 2015, 3 SA 438, SCA. Defined legal proceedings and enforcement action under the moratorium. Chetty v. Hart, 2015. 6 SA 424, SCA, confirmed arbitration falls under the moratorium. SA Airlink Visa, SOC, Limited, 2020, Zaska 156, clarified that the moratorium covers post-commencement claims. Boysen v. Jangkir Boruin Makery, 2017, 4 SA 51, WCC, justified constitutional limitations on access to courts. Nupno v. Forster No, 2019, JDR 1206, GJ, held that moratorium prevents asset execution sales. BP Southern Africa v. Intertrans Oil SA, 2017, 4 SA 592, GJ, confirmed that liquidation applications fall under the moratorium. Kythera Court Villa Rendezvous Café, 2016, 6 SA 63, GJ, held that the moratorium does not prevent eviction after contract cancellation. JBJ Logistics v. Standard Bank, 2016, 6 SA 448, KZD, stated that repossession orders are unaffected by the moratorium. _ This summary maintains comprehensive coverage while streamlining the content for clarity. Let me know if you need any adjustments. Next page. Proceedings excluded from the moratorium. S-133-1 The moratorium on legal proceedings does not apply to criminal proceedings against the company or its directors/officers. S-133-1D Regulatory authority proceedings in execution of duties, after notifying the business rescue practitioner. S-133-1F Trustee-related proceedings where the company exercises trustee powers. S-133-1E must be narrowly interpreted as fiduciary administration, for example, attorneys, estate agents, financial institutions. Case law, Timasani, Proprietary, Limited and another v. Afrimat Iron Ore, Proprietary, Limited, 2021, 3 All SA 843, SCA, 855-6. Proceedings as a set-off against claims initiated by the company, S-133-1C. Likely refers. Next page. Proceedings expressly excluded from the moratorium, S-133-1. The moratorium does not apply to criminal proceedings against the company or its directors/officers, S-133-1D. Regulatory authority proceedings executed in the course of duties, after notifying the business rescue practitioner, S-133-1F. Trustee-related proceedings where the company exercises trustee powers, S-133-1E. Narrowly interpreted as fiduciary administration, for example, attorneys, estate agents, financial institutions. Case law, Taimasani, Proprietary, Limited v. Avrimat Iron Ore, Proprietary, Limited, 2021, 3 All SA 843, SCA, 855-6. Set-off proceedings against claims made by the company in legal proceedings, S-133-1C. Likely refers to counterclaims, not traditional set-off, which extinguishes mutual obligations. Case law. Next page. Proceedings expressly excluded from the moratorium, S-133-1. The moratorium does not apply to criminal proceedings against the company or its directors/officers, S-133-1D. Regulatory authority proceedings executed in the course of duties, after notifying the business rescue practitioner, S-133-1F. Trustee-related proceedings where the company exercises trustee powers, S-133-1E. Narrowly interpreted as fiduciary administration, for example, attorneys, estate agents, financial institutions. Case law, Taimasani, Proprietary, Limited v. Avrimat Iron Ore, Proprietary, Limited, 2021, 3 All SA 843. Next page. Proceedings expressly excluded from the moratorium, S-133-1. The moratorium on legal proceedings does not apply to criminal proceedings against the company or its directors/officers, S-133-1D. Regulatory authority proceedings executed in the course of duties after notifying the business rescue practitioner, S-133-1F. Trustee-related proceedings where the company exercises trustee powers, S-133-1E. Narrowly interpreted as fiduciary administration, for example, attorneys, estate agents, financial institutions. Case law, Taimasani, Proprietary, Limited v. Avrimat Iron Ore, Proprietary. Next. Numbering format. Page 26.1.3. Proceedings expressly excluded from the moratorium, S-133-1. The moratorium on legal proceedings does not apply to 1. Criminal proceedings against the company or its directors/officers, S-133-1D. 2. Regulatory authority proceedings executed in the course of duties after notifying the business rescue practitioner, S-133-1F. 3. Trustee-related proceedings where the company exercises trustee powers, S-133-1E. Narrowly interpreted as fiduciary administration, for example, attorneys, estate agents, financial institutions. Case law, Taimasani, Proprietary, Limited v. Avrimat Iron Ore, Proprietary, Limited, 2021, 3 All SA 843, SCA, 855-6. 4. Set-off proceedings against claims made by the company in legal proceedings, S-133-1C. Interpreted as counterclaims rather than a legal set-off. Case law, Kritzinger and another v. Standard Bank of South Africa, 2013, ZIFSHC 215, September 19, 2013. _ 26.1.4 Lifting of the moratorium. Legal proceedings and enforcement actions within the moratorium can proceed only 1. With written consent of the business rescue practitioner, S-133-1A, or 2. With leave of the court, under terms the court considers reasonable, S-133-1B. Consent from the practitioner and court approval are independent alternatives. Case law, Chetty TA Nationwide Electrical v. Hart and another NNO 2015, 6, SA 424, SCA, 438. Only the High Court may grant leave, S-128-1E. Case law, Marks v. Group 5 Construction, Proprietary, Limited, under supervision, 2020, 41, ILJ 677, LC, 684. I. The court's discretion. The court has broad discretion to grant leave. Leave should not be reserved for exceptional cases. Case law, Ahrens v. Vandermerve NNO 2016, 6, SA 490, GJ, Para 29. Contrary view, Merchant West Working Capital Solutions, Proprietary, Limited v. Advanced Technologies and Engineering Company, Proprietary, Limited 2013 JDR 1019, GSJ, Restrictive Interpretation. Courts consider factors such as 1. Effect on the applicant versus other stakeholders. 2. Impact on the company's well-being and recovery. 3. Whether granting leave hinders business rescue objectives. Case law, Ahrens v. Vandermerveno 2016, 6, SA 490, GJ, 497-8. Case law, SA Airlink Visa, SOC, Limited, 2020, Zaska 156, November 30, 2020. Application for leave refused due to lack of justification. 2. Separate or integrated application. Courts have conflicting views on whether leave must be applied for separately or can be included in substantive proceedings. Separate application required. Elias Mechanicos Building and Civil Engineering Contractors, Proprietary, Limited v. Stedun Developments, Proprietary, Limited 2015, 4, SA 485, KZD. Umsunduzi Municipality v. Uphill Trading 14, Proprietary, Limited 2015 JDR 0702, KZP. Integrated application accepted. VP Southern Africa, Proprietary, Limited v. Intertrans Oil SA, Proprietary, Limited 2017, 4, SA 592, GJ, 598-9. Court granted leave retroactively. Boysen v. Jongkir Boruin Makery, Proprietary, Limited 2017, 4, SA 51. WCC. Standard Bank of SA Limited VC&E Engineering, Proprietary, Limited, 2020, ZAG HC 255, August 14, 2020. Nathan v. Nathan 2021 JDR 1710, KZD. 3. Consequences of failing to obtain consent or leave. 1. The moratorium is a procedural bar only. Failure to obtain leave does not affect jurisdiction. Case law, Chetty TA Nationwide Electrical v. Hardin and other NNO, 2015, 435-6. 2. Orders granted without leave remain valid. Case law, LA Sport 4x4 Outdoor CCB Broadsword Trading 20, Proprietary, Limited 2015 JDR 0405, GP. 3. If an order is obtained without leave, courts assess non-compliance circumstances. Case law, Standard Bank of SA Limited VC&E Engineering, Proprietary, Limited, 2020, Paris 78-9. Example, if a company misled a creditor about its business rescue status, courts may uphold the order despite non-compliance. Next. Page 26.1.5 Enforcement of a guarantee or suretyship given by the company. 1. Enforcement of guarantees and suretyships given by the company is an exception to the moratorium in S-133-1. Case law, Tomasani, Proprietary, Limited v. Afrimat Iron Ore, Proprietary, Limited, 2021, 3 All SA 843, SCA, 853. 2. Court leave is required before enforcement, S-133-2. 3. The court may grant leave under just and equitable terms, S-133-2. 4. Purpose of court involvement. To protect the company from obligations it undertook to secure the debts of others. Not to protect individuals who bound themselves as sureties/guarantors for the company's obligations. Case law, Investec Bank Limited v. Bruins 2012, 5, SA 430, WCC, 436-7. Case law, Business Partners Limited v. Zakiroglu and others 2016, 4, SA 390, WCC. 5. Business rescue does not affect the right to claim against sureties for the company's debts. Case law, Newport Finance Company, Proprietary, Limited v. Nedbank Limited 2016, 5, SA 503, SCA, 508. 26.1.6 Effect on time limits. 1. If the right to commence proceedings or assert a claim against the company is subject to a time limit, that time is suspended during business rescue, S-133-3. Case law, Tomasani, Proprietary, Limited v. Afrimat Iron Ore, Proprietary, Limited, 2021, 3 All SA 843, SCA, 853. 2. The suspension extends the time limit regardless of how much time remained before business rescue began. 3. Difference from the Prescription Act 68 of 1969. The suspension under business rescue extends the time period, while prescription delays only prevent completion of prescription. 4. This extension compensates creditors for delays caused by the moratorium. Next. Page 26.2 Property Interests. 1. Restrictions on the disposal of company property. While under business rescue, a company may dispose of property only if, in the ordinary course of business, in a bona fide arm's-length transaction for fair value, approved in advance and in writing by the business rescue practitioner, S. 134(1)(a), as part of an approved business rescue plan. 2. Restrictions on third-party rights over company property. No person may exercise rights over property lawfully in the company's possession, regardless of ownership, without written consent from the business rescue practitioner. S. 134(1)(c). The practitioner may not unreasonably withhold consent, considering the purpose of business rescue, the company's circumstances, and the nature of the property. S. 134(2). This supplements S. 133(1), which bars legal action against property in the company's possession. 3. Exceptions for third parties possessing company property. If another party lawfully possesses company-owned property under an agreement made before business rescue, that party may continue exercising their rights under the agreement unless the practitioner suspends the agreement or the court cancels it. S. 134(1)(b). 4. Disposal of property subject to security or title interests. The company must obtain prior consent from the holder of the security/title interest unless the sale proceeds fully cover the secured debt. S. 134(3)(a). After disposal, the company must pay the sale proceeds to the secured creditor, up to the company's indebtedness, or provide satisfactory security to the creditor. S. 134(3)(b). If the proceeds are not paid or secured, the purchaser cannot obtain a valid transfer of the property. Case law: Energy Drive Systems, Proprietary, Limited v. Tinkenman, Proprietary, Limited and others 2017, 3, SA 539, GJ, 544. The SCA and Diener Novi Minister of Justice and others 2018, 2, SA 399, SCA, 412 confirmed. Business rescue does not dilute or undermine secured creditors' rights. A company cannot dispose of secured property without consent, unless proceeds fully discharge the debt. 5. Restrictions on the use of secured income streams. The business rescue practitioner may not use income ceded to a creditor without the creditor's consent. Case law: Louis Pasteur Holdings, Proprietary, Limited and others v. ABSA Bank Limited and others 2019, 3, SA 97, SCA, 104. 6. Employee claims versus secured creditors. Employees do not have priority over a secured creditor who obtains security before business rescue. Secured creditors' rights are fully protected against employee wage claims. Case law: National Union of Metalworkers of SA and others VVR Laser Services, Proprietary, Limited and others, 2020, 2 All SA 536, GJ, Para 36. Next. Page 26.3 Employment Contracts. 1. Continuation of employment during business rescue. Employees remain employed on the same terms and conditions as before business rescue, unless changes occur due to ordinary course of attrition, for example, resignation, retirement, dismissal for misconduct/incapacity. Mutual agreement between employees and the company, in line with labor laws, S. 136(1)(a). 2. Retrenchments and business rescue plans. Any retrenchments during business rescue must comply with Sections 189 and 189A of the Labor Relations Act 66 of 1995. Other applicable labor legislation, S. 136(1)(b). Ordinary attrition includes dismissals for misconduct/incapacity, resignations, and retirements. Case law: South African Airways, SOC, Limited, in business rescue, and others v. National Union of Metalworkers of South Africa and others 2021, 2, SA 260, LAC, 270. 3. Restrictions on retrenchments. Retrenchments can only occur if they are contemplated in a business rescue plan. The consultation process under the Labor Relations Act cannot begin until a draft plan proposing retrenchments is presented. Case law: National Union of Metal Workers of South Africa OBO members and another v South African Airways, SOC, Limited, in Business Rescue, and others 2020, 7, BCLR 888, LC. Confirmed on appeal, South African Airways, SOC, Limited, in Business Rescue, and others v National Union of Metal Workers of South Africa and others, Supra. Labor Appeal Court's ruling. Section 131 aims to protect employees from retrenchment before the publication of a business rescue plan. Next. Page 26.4 Other contracts. 1. Importance of contracts in business rescue. Contracts are essential for business continuity, their absence may indicate no reasonable prospect of rescue. Case law, African Banking Corporation of Botswana Limited v Kariba Furniture Manufacturers, Proprietary, Limited and others 2015, 5, SA 192, SCA, 205-6, 214. 2. General principle, contracts remain in force. Business rescue does not automatically affect uncompleted contracts, parties remain bound by their obligations. Similar to sequestration and liquidation, but pari passu, equal treatment of creditors, does not apply in business rescue. Practitioners' special powers exclude employment contracts. Contracts covered under S35A, market infrastructure transactions, and S35B, netting agreements, of the Insolvency Act, S136-2 read with S136-2AB, 2. Case law, Ellerine Brothers, Proprietary, Limited v McCarthy Limited 2014, 4, SA 22, SCA, 27-8. 3. Powers of the business rescue practitioner. Suspension power. Practitioner may suspend entirely, partially, or conditionally any agreement the company was a party to at the start of business rescue, S136-2A. This power applies despite contractual provisions to the contrary. Other party may only claim damages for suspension, S136-3. Practitioner may apply urgently to court for cancellation of any obligation on just and reasonable terms, S136-2B. Security arrangements and creditor rights. If a provision relating to security is suspended, the creditor still retains secured status when the company disposes of the secured asset, S136-2AC. Suspension applies only to obligations not yet due, future obligations. Case law, BP Southern Africa, Proprietary, Limited v Intertrans Oil SA, Proprietary, Limited and others 2017, 4, SA 592, GJ, 602-3, 607-8. If security, for example, cession of book debts, is already in place, the practitioner cannot suspend it. Case law, Louis Pasteur Holdings, Proprietary, Limited and others v Absa Bank Limited and others 2019, 3, SA 97, SCA, 104. 4. Consequences of suspension. Effect on other party. Other party cannot demand specific performance, only a claim for damages. Case law, Cleet Murray and another NNOV First Rand Bank Limited TA Westbank 2015, 3, SA 438, SCA, 446-7. Uncertainty over damages claim status, likely classified as a pre-commencement claim due to lack of ranking provision in S135. Reciprocity of performance. Practitioner cannot force the other party to continue performing if the company's obligation is suspended. Other party may withhold performance under the exception non adimpleti contractus, unfulfilled contract exception. Example, in a lease, rent payment is reciprocal to continued occupation, company cannot stay rent-free. Case law, BP Southern Africa, Proprietary, Limited v Intertrans Oil SA, Proprietary, Limited and others, Supra, 601, 605. 5. Cancellation of contracts. Uncertainty on cancellation for non-performance of suspended obligations. Possible if breach is material and contractual notice requirements are met. Case law, BP Southern Africa, Proprietary, Limited v Intertrans Oil SA, Proprietary, Limited and others, Supra, 601. However, SCA suggests suspension does not justify cancellation. Case law, Cleet Murray and another NNOV First Rand Bank Limited TA Westbank, Supra, 446-7, Kythera Court Villa Rendezvous Café CC and another 2016, 6, SA 63, GJ, 67. Other parties' rights. can cancel for material breach of unsuspended obligations, regardless of timing. Case law, Cleet Murray and another NNOV First Rand Bank Limited TA Was Bank, Supra, Skickerling Novi Chickenland, Proprietary, Limited 2016 JDR 0738, GP. Can terminate contract by notice, for example, bank terminating overdraft. Case law, Kritzinger and another V Standard Bank of South Africa, Supra, First Rand Bank Limited V Singh, Supra, Para 64. Ipso facto clauses, automatic termination upon business rescue commencement, are generally enforceable in South Africa. Case law, First Rand Bank Limited V Singh, Supra, Paras 54-8. Next page. Business rescue, shares, securities, and directors. 26.5 Shares and other securities. During business rescue proceedings, changes in the classification or status of issued securities are invalid unless they occur through the ordinary course of business via transfer by court order under an approved business rescue plan, S-137-1. Uncertainty in interpretation. It is unclear whether the motives of the transferee and transfer patterns affect the determination of an ordinary course transfer. The meaning of classification and status of securities is ambiguous. Classification refers to share types with specific rights and preferences, S36(1), 2. Status depends on whether shares are issued and outstanding or authorized but unissued, S35(5). The first exception suggests that a share transfer affects its classification and status, but this is incorrect. Likely inserted to clarify share transfers rather than redefine classification/status. If a business rescue plan changes the classification and status of securities, a vote by security holders is required, S-152(3)(c). 26.6 Directors. Powers during business rescue. The business rescue practitioner, BRP, has full management control of the company, replacing the board and management, S-141A. Directors must continue exercising director functions, subject to BRP authority. Carry out management functions only as per BRP's instructions. Provide the BRP with any required company information, S-137-2, 3. Legal interpretation and case law. Director's role should not manage business rescue while the BRP remains passive. Boyce and V. Jongir Borui Makeri 2017, 4, SA 51, WCC. Distinction between governance and management. Governance/internal functions includes presenting financial statements, issuing shares, convening shareholder meetings, and proposing resolutions. Raghavan V. Optimum Coal Terminal 2022, 3, SA 512, GJ. Management functions concern external matters and require explicit BRP instructions. Van Jaarsveld Novi Q Civils 2018 JDR 0977, FB. Business rescue limits director powers. Directors cannot act on behalf of the company in opposing liquidation. Van Jaarsveld Novi Q Civils. Voting rights. The company's vote on another company's business rescue plan is a management function, exercised by the BRP. Raghavan V. Optimum Coal Terminal. Exception. The Constitutional Court held that appointing a replacement BRP, S-139-3, is a board function, not a management function. Shiva Uranium v. Tayab 2022, 3, SA 432, CC. Legal restrictions and liabilities. Directors cannot take actions on behalf of the company that require BRP approval. Such actions are void without approval. S-137-4. Directors remain subject to disclosure duties, S-75. Exemption from duties and liabilities, S-76 and S-77, except acting without authority, S-77-3A. Allowing reckless, grossly negligent, or fraudulent business conduct, S-77-3B. Read with S-22-1. Being party to acts/omissions intended to defraud stakeholders, S-77-3C. Obligations to the business rescue practitioner. Must assist and cooperate with the BRP. Klauber Novi Raghavan 2018 JDR 1258, GJ. Required to hand over company records, S-142-1. Inform BRP of the location of other records, S-142-2. Provide a statement of the company's affairs within 5 business days, or extended time granted by BRP, S-142-3. Director removal by court order, S-137-5. The BRP may apply for a director's removal if The director fails to comply with Chapter 6 requirements. The director impedes the BRP's functions, management, or rescue plan implementation. This summary highlights key provisions, interpretations, and case law concerning shares, securities, and director responsibilities during business rescue proceedings. Let me know if you need further elaboration. Next page. Here are your detailed study notes on shares and other securities and directors in business rescue, as well as the beginning of Chapter 27, Conduct of Business Rescue Proceedings. _ 26.5 Shares and other securities. During business rescue, changes to the classification or status of issued securities are invalid unless by transfer in the ordinary course of business in terms of a court order under an approved business rescue plan. S-137-1. Uncertainty in interpretation. It is unclear whether transfer motives and the company's transfer history are relevant. The terms classification and status remain ambiguous. Classification, division of shares with preferences, rights, and terms. S-36-1, 2. Status, whether shares are issued, outstanding, or authorized but unissued. S-35-5. Exception regarding share transfers likely intended to clarify transfers rather than redefine classification/status. If a business rescue plan alters securities classification or status, it requires a vote by the affected securities holders. S-152-3C. _ 26.6 Directors. Management shift during business rescue. The business rescue practitioner, BRP, assumes full management control, replacing the board. S-141A. Directors must still perform director functions, subject to BRP authority. S-137-2, 3. Directors' responsibilities include complying with the BRP's instructions for management functions, providing information about company affairs as required. Case law on director functions versus BRP control. Boyson v. Jonkir Boruin Makery, Proprietary, Limited 2017, 4, SA 51, WCC. BRP must take an active role, not allow directors to run business rescue. Raghavan v. Optimum Coal Terminal, Proprietary, Limited 2022, 3, SA 512, GJ. Director functions, internal governance, for example, financials, issuing shares, meetings. Management functions, external affairs, requiring BRP's explicit instruction. Van Jaarsveld no VQ Civils, Proprietary, Limited 2018 JDR 0977, FB. Directors cannot act on behalf of the company in liquidation opposition. Shiva Uranium, Proprietary, Limited VTAB 2022, 3, SA 432, CC. Board retains authority to appoint a replacement BRP under S-139-3. Director actions require BRP approval. Acts by directors requiring BRP approval are void if not approved. S-137-4. Directors remain bound by duty to disclose personal financial interests. S-75. Limited liability during business rescue. Directors are not liable under S-76 and most of S-77, unless acting without authority. S-77-3A. Allowing reckless trading. S-77-3B. Read with S-22-1. Participating in fraud. S-77-3C. Director cooperation obligations. S-142. Deliver company books and records to the BRP. Inform BRP of missing records. Provide a statement of affairs within 5 business days. BRP may remove directors. S-137-5, if a. Violate business rescue rules. Obstruct the BRP in company management or business rescue plan implementation. Chapter 27, Conduct of Business Rescue Proceedings. 27.1 The Business Rescue Practitioner, BRP, central role in business rescue. Takes over management control and develops the rescue plan. S-128-1B. 27.1.1 Qualifications. Must be a member in good standing of an accredited legal, accounting, or business management profession. Licensed by the Commission. S-138-1A. B. Ministerial regulations. Establish minimum qualifications and licensing standards. S-138-3. BRP classification based on experience. Senior BRP can handle any company. Experienced BRP handles small/medium companies or assists seniors in large/state-owned companies. Junior BRP handles small companies or assists experienced/senior BRPs. Reg 127-3, 5. Company size classification. Determined by the public interest score, based on turnover, employees, shareholding, and liabilities, Reg 127-2B, Reg 26-2. Disqualifications. BRP cannot be appointed if subject to probation as a director, S 138(1)(c), D. Has a conflict of interest that compromises impartiality, S 138(1)(e), F. Underscore. 27.1.2 Appointment of the BRP. I. Voluntary business rescue. The company appoints the BRP within 5 business days of filing the resolution. The BRP must consent in writing, S 129(3)(b). Filing and notice. Appointment must be filed within 2 business days, S 129(4)(a). Notice to affected persons within 5 business days, S 129(4)(b). Affected person's right to challenge, S 131(b). BRP does not meet qualifications, S 138. BRP lacks independence from management. BRP lacks required skills for the company's situation. Court's power. Can order BRP to provide security for affected persons, S 131(c). If the BRP is removed, the court appoints a replacement BRP recommended by independent creditors, S 136(a). Replacement BRP appointment. If a court-appointed BRP resigns, the board, not the court, appoints a new BRP, S 139(3). This is not a management function, so no BRP authorization is needed. Teod v. Shiva Uranium 2020 Zasco 162 para 18. 2. Compulsory business rescue. Court-appointed BRP must meet eligibility requirements. Must be nominated by the applicant, S 131(5). Ratification by creditors. The BRP's appointment must be ratified by a majority of independent creditors at the first creditors' meeting, S 131(5). Underscore. This summary maintains detailed legislative references and case law, following your preferred structured, bullet point format with a focus on legislation and court decisions. Let me know if you'd like further refinements or more sections from Chapter 27. Next page. Chapter 27, Conduct of Business Rescue Proceedings. 27.1 The Business Rescue Practitioner. Business rescue proceedings involve temporary supervision of the company by an independent business rescue practitioner, BRP, S 128(1)(b). 27.1.1 Qualifications. A BRP must be a member in good standing of a legal, accounting, or business management profession accredited by the Commission, licensed by the Commission, S 138(1)(a). B. The Minister sets minimum qualifications and licensing standards, S 138(3). Regs 126 to 127. BRPs are classified based on experience, Reg 127(3), 5. Senior practitioners can be appointed for any company. Experienced practitioners can be appointed for small/medium companies or assist a senior practitioner in large/state-owned companies. Junior practitioners can be appointed for small. 27.1.3 Removal and replacement of a business rescue practitioner. The court may remove a business rescue practitioner, BRP, if there is an objection to their appointment under a business rescue resolution, S 139(1), read with S 131(b), c. The BRP is incompetent or fails to perform their duties, fails to exercise proper care in performing their functions, engages in illegal acts or conduct, has a conflict of interest or lacks independence, no longer satisfies appointment requirements, is incapacitated and unlikely to regain capacity within a reasonable time, S 139(2). Grounds for removal must be proven on a balance of probabilities and inferred from primary facts rather than speculation. Nupno and another v. Gupta and another 2021. 3, SA 88, SCA 96, 121 FF. The court has discretion to remove a BRP upon proving a ground, Item 95. Removal is not ordered lightly. The court considers stakeholders' interests, Item 95-6. African Banking Corporation of Botswana Limited v. Kariba Furniture Manufacturers. Proprietary, Limited and others 2015, 5, SA 192, SCA 206-8. Failure to meet time limits for administrative steps does not indicate incompetence. Absa Bank Limited v. Nodno and another, 2014, Zuck page C 181. Replacement of the removed practitioner. If a BRP dies, resigns, or is removed, The nominating company or creditor must appoint a new BRP, S-139-3. The term creditor should include any nominating affected person, Shiva Uranium, Proprietary, Limited, in Business Rescue, and another VTAB and others 2022, 3, SA 432, CC, 443. Involuntary business rescue proceedings. Any affected person may apply to court under S-131B or C. 2. Set aside the new appointment. Require the practitioner to provide security. S-139-3. A BRP's authority automatically ends when business rescue proceedings end. Commissioner for the South African Revenue Service v. Primrose Gold Mines, Proprietary, Limited and others, 2016, ZUC page C737. _ 27.1.4 General functions and duties of a business rescue practitioner. The BRP assumes full management control of the company, replacing the board and management, S-141A. The BRP must actively participate and not be a passive figurehead. Boyce and V. Jonkir Boruin Makery, Proprietary, Limited and another 2017, 4, SA 51, WCC, 77-9. The BRP may delegate powers to directors or management. Remove or appoint members of management, S-141B. 2. The BRP must inform regulatory authorities of the company's business rescue status as soon as possible, S-141A. The BRP's primary functions include investigating the company's affairs, developing and implementing a business rescue plan, access to records. No person can retain possession of company records against the BRP unless they lawfully possess the records. They provide copies or allow reasonable inspection, S-142-4. Reporting obligations. If business rescue proceedings exceed 3 months, the BRP must prepare and update monthly progress reports, deliver reports to affected persons and the court, if ordered, or the company's commission, S-132-3. Legal status and liability. The BRP is an officer of the court, S-143A, requiring high integrity, Nupno and another V. Gupta and another 2021, 3, SA 88, SCA. 102-3. The BRP is subject to directors' duties and liabilities under SS 75-77, S 143B. The BRP is liable only for gross negligence and not for acts done in good faith, S 143C. Courts may grant relief from liability under S 77-9 if the BRP acted honestly and reasonably. Van den Heever Novi van Tonder 2021 JDR 2612, GJ. If a company enters liquidation, the BRP cannot be appointed as the liquidator, S 144. Next page. 27.1.5 Remuneration of the Business Rescue Practitioner. Prescribed tariff for remuneration. A business rescue practitioner, BRP, is entitled to remuneration and expenses per a prescribed tariff, S 143-1. The tariff is based on company size, Reg 127-2, and consists of an hourly rate with a daily maximum. Small company, R1,250/hour, max R15,625 per day. Medium company, R1,500/hour, max R18,750 per day. Large/state-owned company, R2,000/hour, max R25,000 per day. Reg 128-1. Expenses and disbursements. The BRP may claim disbursements for actual and reasonable expenses necessary for business rescue functions, Reg 128-3. Expenses include payments for advisors assisting in the business rescue process, Murgatroyd v. Van den Heever and others NNO 2015, 2, SA 514, GJ, 523-4. Additional contingency-based remuneration. A BRP may negotiate additional remuneration based on adoption of a business rescue plan, including within a set time frame or with specific provisions. Achievement of specific business rescue outcomes, S 143-2. The company must approve the additional remuneration at a meeting where a majority of independent creditors' voting interests support it. A majority of shareholders entitled to a portion of the company's residual value support it. S 143-3. A creditor or shareholder who voted against the agreement may apply to court within 10 business days to set it aside if the agreement is unjust and inequitable. The remuneration is unreasonable, given the company's financial circumstances. S 143-4. Section 143 does not regulate success fees negotiated with third parties. Carrot Co., Proprietary, Limited v. Independent Advisory, Proprietary, Limited 2020, 5, SA 35, SCA, 40. Ranking of remuneration and expenses. The BRP's claim for remuneration and expenses ranks ahead of all secured and unsecured post-commencement finance claims, S143-5, S135-3. If business rescue transitions to liquidation, the BRP's claim remains preferential but ranks behind the costs of liquidation, S135-4. No super preference over pre-commencement secured claims. S143-5 applies only to post-commencement finance claims, Diener No v. Minister of Justice and others 2018, 2, SA 399, SCA, 415-16. Confirmed by the Constitutional Court in Diener No v. Minister of Justice and Correctional Services and others 2019, 4, SA 374, CC. Next. Page 27.2 Investigation of affairs of the company. Practitioner's duty to investigate. The business rescue practitioner, BRP, must investigate the company's affairs, business, property, and financial position as soon as practicable after appointment, S141-1. The purpose is to determine whether there is a reasonable prospect of the company being rescued. Actions based on investigation findings. 1. No reasonable prospect of rescue. If the BRP concludes that business rescue will not succeed, they must inform the court, company, and affected persons in the prescribed manner. Apply to court for an order to discontinue business rescue and commence liquidation, S141-2A. 2. Company is no longer financially distressed. If the BRP determines that the company is no longer financially distressed, they must inform the court, company, and affected persons. Apply to court for termination if business rescue was initiated or confirmed by a court order. Otherwise, file a notice of termination, S141-2B. 3. Voidable transactions or failure to perform obligations. If the BRP finds voidable transactions or failure to perform material obligations, they must take necessary steps to rectify the matter. Direct management to take appropriate actions, S141-2CI. Sections 29 to 31 of the Insolvency Act do not apply to business rescue proceedings. Oakdean Square Properties, Proprietary, Limited v. Farm Boats Fontaine, Kyalami, Proprietary, Limited 2012, 3, SA 273, GSJ, 290, Engen Petroleum Limited v. Multi-Waste, Proprietary, Limited and others 2012, 5, SA 596, GSJ, 598, 602. Voidable transactions in this context refer to those voidable under contract law principles. 4. Reckless trading, fraud, or legal contraventions. If the BRP finds evidence of reckless trading, fraud, or other legal contraventions, they must forward the evidence to the appropriate authority for investigation and prosecution. Direct management to take necessary steps, including recovering misappropriated assets, S141-2C. 2. Ongoing monitoring obligations. The BRP must continuously monitor the company's affairs during business rescue. If at any time they conclude business rescue is no longer viable, the company is no longer financially distressed, there is evidence of voidable transactions or unlawful conduct, they must take the appropriate steps as prescribed in S141-2. Next. Page 27.3 Financing during business rescue proceedings. 27.3.1 Power to obtain secured and unsecured financing. During business rescue proceedings, a company may obtain financing, which can be secured by unencumbered company assets, unsecured, relying on the company's creditworthiness, S135-2. Post-commencement financing, PCF, is often crucial for business rescue success but can be difficult to secure. Bradstreet, 2011, 128 SL 352-359. Employee claims as post-commencement finance. Employee claims for salaries, expenses, and employment-related payments, for example, bonuses, commissions, incentives, accrued during business rescue proceedings are treated as post-commencement financing, S135-1, Boyson v. Jonkheer Boruin Makery, Proprietary, Limited and another 2017, 4, SA 51, WCC, 75. The Companies Act is silent on whether unpaid rental under continuing contracts with divisible performance, for example, leases, constitutes post-commencement finance. In South African Property Owners Association v Minister of Trade and Industry and Others 2018, 2, SA 523, GP, the court rejected a claim that unpaid rental was either post-commencement financing or part of the costs of business rescue, Item 528-9. 27.3.2 Ranking of post-commencement claims. Employee claims for post-commencement salaries and benefits rank equally and have preference over all other post-commencement finance claims, S135-1, S135-3A. Other post-commencement financing ranks below the practitioner's remuneration and business rescue costs, S135-3. Claims are ranked in order of incurrence and have preference over all unsecured claims, S135-2, S135-3B. If business rescue ends in liquidation, post-commencement financing claims retain priority but rank below the costs of liquidation, S135-4. The ranking system creates an anomaly where business rescue claims outrank execution costs under S98 of the Insolvency Act, C 16.3.2 on ranking of free residue claims. Dean no case, no super preference for practitioners' claims. The practitioner's claim does not enjoy a super preference over pre-commencement secured claims. Dean no v Minister of Justice and Others 2018, 2, SA 399, SCA 415-16, confirmed by the Constitutional Court in Dean no v Minister of Justice and Correctional Services and Others 2019, 4, SA 374, CC, held that business rescue practitioners' fees do not rank above secured pre-commencement claims. The ranking applies only to post-commencement finance claims. Confusion from Merchant and Redpath cases. In Merchant West Working Capital Solutions, Proprietary, Limited v Advanced Technologies and Engineering Company, Proprietary, Limited 2013 JDR 1019, GSJ, Para 21. The court suggested a ranking of pre- and post-commencement claims that did not align with S134 and S135. The same incorrect ranking was repeated in Redpath Mining South Africa, Proprietary, Limited v Marsden No 2013 JDR 1410, GSJ, Para 60, ignoring secured creditors' priority over encumbered assets. VR Laser Services case, correct interpretation of ranking. In National Union of Metalworkers of SA and Others VBR Laser Services, Proprietary, Limited and Others, 2020, 2 All SA 536, GJ. Employees objected to the payment of secured pre-commencement creditors ahead of their post-commencement finance claims. Employees relied on the merchant case ranking, arguing their claims should be paid first from secured creditors' proceeds. Court rejected the claim, stating, post-commencement employee claims rank above post-commencement secured finance, S135-3. Pre-commencement secured claims remain fully protected by S134-3 in common law, Item 553. Only post-commencement finance ranking is governed by S135, Item 551. The VR Laser Services case provided the correct interpretation of the Companies Act and business rescue claim priorities. Next. Page 27.4 Rights of affected persons. Definition of affected persons. An affected person includes, S128(1)(a), shareholders, creditors, registered trade unions representing employees, individual employees, if not represented by a trade union, or their representatives. Rights of affected persons. Notification of key events in business rescue. Participation in legal proceedings. Actions upon rejection of the business rescue plan. Rights differ concerning input on the business rescue plan, voting on the plan, participation in court proceedings. Affected persons have a statutory right to intervene in legal proceedings without requiring leave. Tomasani, Proprietary, Limited and Another v. Afrimat Iron Ore, Proprietary, Limited, 2021, 3 All SA 843, SCA, 849-50. Underscore 27.4.1 Employees. Rights of employees in trade unions during business rescue. Trade unions representing employees and unrepresented employees are entitled to S144(1), 3. Receive notice of all court proceedings, decisions, and meetings related to business rescue. Participate in court proceedings during business rescue. Consultation with a business rescue practitioner regarding the rescue plan. Review and submit input on the proposed business rescue plan. Attend and present submissions at the creditors' meeting before voting on the rescue plan. Vote on the business rescue plan only if the employee is a creditor. Propose an alternative plan if the proposed plan is rejected. Make an offer to acquire voting interests from those opposing the adoption of a rescue plan. S-153-1B, 2. Trade unions versus individual employees. Trade unions exercise rights collectively on behalf of employees. S-144-1A. A registered trade union has additional rights, such as access to company financial statements to apply for business rescue proceedings. S-31-3. Employees not represented by a union may exercise rights individually or through a proxy. S-144-1B. Employees and trade unions may establish a committee of employee representatives. S-144-3C. Employee claims in business rescue. Unpaid pre-commencement remuneration and expenses. Employees are classified as preferred unsecured creditors. S-144-2. Business rescue plan must classify claims according to insolvency law. S-152A, 2. Unlike insolvency law, which limits employee preferred claims under S-98A of the Insolvency Act, full employee claims must be prioritized under business rescue. Commissioner, South African Revenue Service v. Beginsel No and others 2013, 1, SA 307, WCC, 316. Ranking of pre-commencement claims depends on the business rescue plan. S-152BB. Pension and medical schemes as creditors. Medical, pension, and provident schemes for past/present employees are unsecured creditors for unpaid employer contributions due at the commencement of business rescue. S-144-4A. Defined benefit pension schemes qualify as unsecured creditors for any unfunded liabilities at the start of business rescue. S-144-4B. Next. Page 27.4.2 Creditors. Rights of creditors in business rescue. S-145-1. To each creditor is entitled to receive notice of all court proceedings, decisions, meetings, and relevant events. Participate in court proceedings related to business rescue. Participate formally in business rescue proceedings as provided in Chapter 6. Participate informally by making proposals for a business rescue plan to the practitioner. Vote to amend, approve, or reject a proposed business rescue plan. Propose an alternative plan if the proposed plan is rejected. Make an offer to acquire voting interests of those opposing the business rescue plan. S-153-1B, 2. Voting interests of creditors. S-145-4, 5. Secured and unsecured creditors' voting interests equal to the value of their claims. S-145-4A. Concurrent creditors with subordinated claims voting interest is based on what they would receive in liquidation. S-145-4B. This amount must be determined by an independent expert valuation. S-145-5B. Subordinated creditors equals creditors who voluntarily agreed to rank lower in liquidation. Commissioner, South African Revenue Service v. Beginsel No and others 2013, 1, SA 307, WCC, 315-16. Creditors Committee and Consultation, S-145-3. Creditors may form a committee and must be consulted by the business rescue practitioner. Only independent creditors, not related to the company, its directors, or the practitioner, can be members. S-128-1G. The practitioner determines creditor independence. S-145-5A. Notice requirements. At least 15 business days before the meeting to consider the business rescue plan, the practitioner must inform each creditor of their classification, independent or not. Notify subordinated creditors of the valuation of their claims. S-145-5C. A creditor may apply to court for a review of the practitioner's decision. S-145-6. Underscore. 27.4.3 Securities holders. Rights of securities holders in business rescue. S-146. Each holder of issued securities, including shareholders, has the right to receive notice of all court proceedings, decisions, meetings, and relevant events. Participate in court proceedings related to business rescue. Formally participate in the company's business rescue proceedings under Chapter 6. Vote on the business rescue plan if it affects the rights attached to their class of securities. Propose an alternative plan if the business rescue plan is rejected. S-153. See 27.6.7i. Make an offer to acquire the voting interests of those opposing the business rescue plan, S-153(1)(b). 2. See 27.6.73. Rights of holders of debt instruments, debentures. Debenture holders are also creditors and can vote in that capacity regarding debts owed to them. If the business rescue plan affects their rights, they can vote as securities holders, S-152(3)(c). Next page. Business rescue proceedings, key aspects. 27.4.2 Creditors' rights. Creditors have the right to receive notices of court proceedings, decisions, meetings, and relevant events. Participate in court proceedings and business rescue proceedings, formal and informal. Vote on a business rescue plan and propose amendments or alternatives. Make an offer to acquire voting interests of those opposing the plan under S-153(1)(b). 2. Voting interests. Determined by the value of claims, secured and unsecured creditors. Subordinated creditors have voting rights based on expected liquidation payout. S-145(4)(b). Independent expert valuation required for subordinated creditors, S-145(5)(b). Case law, Commissioner, South African Revenue Service v. Ginsel No and others 2013, 1, SA 307, WCC, confirms subordinated creditors' rights in liquidation scenarios. Creditors' Committee can be formed for consultation during business rescue. Only independent creditors, not related to the company, directors, or practitioner, may be members. Practitioner must classify creditors as independent and notify them at least 15 business days before the plan meeting, S-145(5)(c). Creditors can apply for a court review of the practitioner's classification, S-145(6). 27.4.3 Securities holders' rights. Securities holders, shareholders and debenture holders, have rights similar to creditors, including receiving notices of proceedings and participating in court cases, voting on a rescue plan if it affects their class of securities, proposing alternatives to rejected plans under S-153, making offers to acquire opposing voting interests under S-153(1)(b). 2. Debenture holders. Considered creditors and may vote on debts owed to them. If the rescue plan affects their special privileges, they vote as securities holders under S-152(3)(c). 27.5 Meetings and Committees. 27.5.1 First Meeting of Creditors. Practitioner must convene within 10 business days of appointment, S-147(1). Agenda includes practitioner's view on prospects of rescuing the company, proof of claims submission by creditors, decision on forming a creditors' committee, decision-making, simple majority of independent creditors' voting interests, S-147(3). 27.5.2 First Meeting of Employees' Representatives. Must be held within 10 business days of appointment, S-148(1). Purpose. Practitioner informs employees about rescue prospects. Employees decide on forming an employees' committee. Notice of meeting must be given to trade unions representing employees, non-union employees or their representatives, S-148(2). 27.5.3 Committees' Functions and Membership. Functions. Consult with the practitioner, but cannot direct decisions. Receive and review reports on business rescue proceedings, S-149(1). Membership requirements. Must be independent creditors or employees. Can be an agent, proxy, or attorney of an independent creditor/employee. Must have written authorization from an independent creditor/employee, S-149(2). 27.6 The Business Rescue Plan. Core document for restructuring the company to continue operations on a solvent basis. Provide creditors/shareholders with a better return than liquidation, S-128(1)(b). 2. Practitioner must consult creditors, affected persons, and management before drafting the plan, S-151. Case law. Oakdean Square Properties, Proprietary, Limited v. Farm Boats Fontaine, Kyalami, Proprietary, Limited 2013. 4. SA 539, SCA. Rescue plan cannot be a precondition for commencing business rescue. Liamisa Investment Holdings, RF, Limited v. Vander Merveno 2015 JDR 2231, GP. Consultation must be meaningful, not just informative. 27.6.1 Content of the Business Rescue Plan. Must include 3 parts, S-152. A. Background. Company assets, secured versus unsecured. List of creditors, secured, prefer, concurrent, and proven claims. Probable liquidation dividend for each class of creditors. List of issued securities holders. Practitioner's remuneration agreement. Statement on informal creditor proposals. B. Proposals. Moratorium on debt payments. Debt restructuring. Extent of debt release/conversion into equity. Ongoing company operations and treatment of agreements. Assets available to pay creditors. Payment order for creditor claims. Comparison of expected returns in rescue versus liquidation. Impact on different securities holders. C. Assumptions and conditions. Conditions for plan execution and implementation. Impact on employees and employment terms. Events that trigger plan termination. Projected financials, balance sheet, income statement, for 3 years. Certification requirement. Practitioner must confirm that actual data is accurate and projections are made in good faith. S-154. Case law on plan content. Commissioner, South African Revenue Service v. Ginsel and others 2013, 1, SA 307. WCC, substantial compliance with S-152 is sufficient. Van Zale v. Auto Commodities, Proprietary, Limited 2021, 5, SA 171, SCA, S-154-1 allows creditors to lose enforcement rights if they accept debt discharge. Key considerations. Liquidation comparator. Comparing rescue versus liquidation outcomes is essential in assessing plan feasibility. Must disclose creditor security, classification, and potential liquidation payout. Post-commencement financing priority. S-135 governs priority of new financing. Pre-commencement employee claims rank separately from other creditors. Moratorium and debt release. Moratorium can be beyond statutory moratorium in S-133. Debt release must align with S-154-1. _ This summary maintains all relevant details while focusing on the legal framework, rights, and obligations under the Companies Act, Chapter 6, supported by case law interpretations. Let me know if you need more emphasis on specific sections. Next page. Study notes, Business Rescue Plan, Publication, Meeting, and Legal Effects 27.6.2 Publication of Plan. The Business Rescue Plan must be published within 25 business days of the practitioner's appointment, unless an extension is granted by the court, on application by the company, or creditors holding the majority of voting interests. S-155. Conflicting court decisions on granting an extension. D.H. Brothers Industries, Proprietary, Limited v. Gribnitz and others 2014, 1, SA 103, KCP. Extension requires a vote at a properly convened meeting. ABSA Bank v. Golding Dividend 39, Proprietary, Limited and others 2015, 5, SA 272, GP. Extension valid if the creditor holding the majority of voting interests consents. Blue Nightingale 709, Proprietary, Limited Beanquay Platinum South Africa, Proprietary, Limited 2021 JDR 2747, GJ, Paras 73-74, also discuss this issue. Consequences of failure to publish plan. D.H. Brothers Industries, Proprietary, Limited v. Gribnitz and another, Supra. Business rescue proceedings are automatically terminated. ShopRite Checkers, Proprietary, Limited v. Berryplum Retailers CC and others, 2015, Zuck page C255, no automatic termination, as there is no express provision in the Companies Act. _ 27.6.3 Meeting to consider and vote on plan. Practitioner must convene and preside over a meeting within 10 business days of plan publication, S-151-1. Participants. Creditors, pre-commencement creditors, other holders of voting interests, for example, securities holders affected by the plan, National Union of Metalworkers of SA and others VBR Laser Services, Proprietary, Limited and others, 2020, 2 All SA 536, GJ, 545, 550. Notice of meeting, S-151-2. Must be given at least 5 business days before the meeting, must include date, time, place, agenda, and summary of rights to participate and vote. Duties of practitioner at the meeting, S-152-1. Introduce the plan and confirm if there is still a reasonable prospect of rescue, S-152-1A. B. Allow employees' representatives to address the meeting, S-152-1C. Invite discussion and voting on motions to amend the plan or adjourn the meeting for revisions, S-152-1D. Call for a vote for preliminary approval, unless adjourned, S-152-1E. Voting process. Plan receives preliminary approval if creditors holding more than 75% of voting rights approve. At least 50% of independent creditors, if any, vote in favor, S-152-2. If not approved, the plan is rejected, S-152-3A. Final approval. If the plan does not alter the rights of securities holders, preliminary approval is final, S-152-3B. If the plan affects securities holders, they must vote separately. Majority in favor plan is adopted. Majority against plan is rejected, S-152-3C. Underscore. 27.6.4 Legal effect of the plan. I. General effect. Once approved, the plan binds the company, all creditors and securities holders, whether they attended or voted, S-152-4. A creditor may lose the right to enforce a discharged debt if they agree to it in the plan, S-154-1. Key case law on creditor rights. Van Zale v. Auto Commodities, Proprietary, Limited 2021, 5, SA 171, SCA. A creditor must accede, i.e., voluntarily agree, to debt discharge. No compulsory deprivation of a creditor's claim, P.181. Raven Construction CCV Beckerno and others 2016, 6, SA 589, SCA. Even creditors not informed of the business rescue lose enforcement rights, p. 594-5. Effective implementation, S-154-2. Once the plan is implemented, pre-commencement debts cannot be enforced, except as provided in the plan. Van Zale v. Auto Commodities, Proprietary, Limited, Supra. The company is personally protected from enforcement, P.182-3. The debt is not extinguished, only enforcement against the company is prevented. 2. Effect on sureties. Key distinction from S-155 compromises. In S-155 compromises, sureties remain liable, S-155-9. In business rescue, the Act is silent on the effect on sureties. SCA case law clarifying surety liability. Van Zale v. Auto Commodities, Proprietary, Limited, Supra, 176-7. Sureties remain liable unless the creditor explicitly agrees to discharge the principal debt. Newport Finance Company, Proprietary, Limited and another v. Nedbank Limited 2016, 5, SA 503, SCA, 507. Common law applies, accessory liability follows the principal debt. Tuning Fork, Proprietary, Limited TA Balanced Audio v. Greff and another 2014, 4, SA 521, WCC, 530-2. Adopting a business rescue plan does not extinguish the principal debt, so surety remains liable. Zungu Elgin Engineering, Proprietary, Limited v. Genie Industrial Holdings, Proprietary, Limited 2020 JDR 2673, SCA, paras 11-14. A surety or guarantor becomes a creditor only after paying the principal debt. Until payment, they are not contingent creditors in the business rescue plan. Underscore. Summary of key points. Plan publication, within 25 business days, unless an extension is granted. Meeting to consider the plan, must occur within 10 business days of publication. Voting threshold for approval. 75% of creditor voting rights. 50% of independent creditors, if applicable. Legal effect of approval. Binding on all creditors and shareholders. Pre-commencement debts cannot be enforced, except as per the plan. Creditors must consent to a debt discharge, no compulsory write-off. Effect on sureties. Sureties remain liable unless the principal debt is explicitly discharged by creditor agreement. This summary provides a structured and detailed breakdown of the publication, meeting, and legal effects of a business rescue plan, including relevant case law and legislative provisions. Next page. Business Rescue Plan, Implementation, Amendment, and Non-Adoption. 27.6.5 Implementation of Plan. Practitioner must ensure all conditions attached to the approval of the plan are met and implemented as adopted, S-152-5. Practitioner may issue authorized securities and determine their consideration, overriding S-38 and S-40, S-152-6A. If approved by shareholders, the practitioner can amend the Memorandum of Incorporation to authorize securities issuance, overriding SS 16, 36 and 37. S-152 6b. Shareholders' preemptive rights do not apply unless the plan states otherwise. S-152 7. Once substantially implemented, practitioner must file a notice to terminate business rescue proceedings. S-152 8. Read with S-132 2c. 2. 27.6.6 Amendment of an adopted plan. No provision in the Act for amending an adopted plan. Courts cannot amend, vary, or enforce changes to a business rescue plan. Krantz-Fontaine Beleggings, Proprietary, Limited v. Corlink 25, Proprietary, Limited 2017 JDR 1577, SCA. Plan cannot reserve a right for the practitioner to amend it after adoption, as this would bypass the majority vote requirement. Boyson v. Jonkir Boruin Makery, Proprietary, Limited and another 2017, 4, SA 51, WCC, 76-7. Courts can set aside a plan that was not properly adopted. Absa Bank Limited v. Nodno and others 2016, 6, SA 540, SCA, but affected persons who voted for the plan must be joined as parties. 27.6.7 Non-adoption of plan. If rejected, the practitioner may seek approval to prepare and publish a revised plan or apply to set aside the vote if it was inappropriate. S-153 1a. If the practitioner does not act, any affected person present at the meeting may call for a vote requiring the practitioner to prepare and publish a revised plan or apply to court to set aside the vote. S-153 1bi. Alternatively, an affected persons may offer to acquire the voting interest of dissenting voters at a price set by an independent expert. S-153 1b. 2. Before these options arise, the plan must have been put to a vote and rejected. A postponed meeting does not constitute rejection. South African Bank of Athens Limited v. Zenny's Fresh Fruit CC 2018, 3, SA 278, WCC 286. While these steps are pending, if the practitioner concludes rescue is no longer viable, they must apply for liquidation. S-141 2a, Nadu v. Mishono 2020 JDR 0008, KZP, Paris 50-3. If no action is taken after rejection, business rescue terminates, and the practitioner must file a termination notice. S-153 5. Filing is a governance step, not a precondition for termination. Rogel Holdings, Proprietary, Limited v. Victor Turnkey Projects, Proprietary, Limited and others 2022 JDR 1031, GP, Paris 41-3. Rejection is a sufficient ground for termination. S-132 2CI, the Land and Agricultural Development Bank of South Africa v. Agri Oil Mills, Proprietary, Limited 2021 JDR 1238, KCP, Paris 32-4. I. Revised Plan. If a vote directs the practitioner to prepare a revised plan, the meeting must conclude. Practitioner has 10 business days to publish the revised plan. S-153 3. The standard procedure for notification and meeting convening applies. Practitioner cannot revise the plan without a vote by affected parties. Rogel Holdings, Proprietary, Limited v. Victor Turnkey Projects, Proprietary, Limited and others Para 46. 2. Setting aside a vote is inappropriate. If a vote is to be challenged in court, the meeting must adjourn for 5 days, unless the application is made within that time or the court disposes of the matter. S-153 2. The resumed meeting must inform affected persons whether an application was made and its outcome. Ferrostal GmbH and another v. Transnet Soak Limited and another 2021, 5, SA 493, SCA. If the court sets aside the vote, the plan is deemed adopted by law without a further vote. First Rand Bank Limited v. KJ Foods CC 2017, 5, SA 40, SCA. 61. The court considers whether setting aside the vote is reasonable and just, taking into account interests of those who voted against the plan, provisions in the plan regarding their interests, a fair estimate of their return on liquidation. S-153 7a, c. Creditors may vote in their own economic interest. Nadu v. Mishono Paris 41-4, ShopRite Checkers, Proprietary, Limited v. Berryplum Retailers CC, 2015. Zuck page C255 para 38. A vote is valid if it aligns with fair balancing of stakeholders' rights. Ferrostal GmbH and another V Transnet Soak Limited and another, Supra, 503-506. If a creditor votes with ulterior motives, the vote may be set aside. Collard v. Yatara Connect, Proprietary, Limited and others 2018, 5, SA 238, WCC, 247. Determining whether a vote is inappropriate involves a value judgment. First Rand Bank Limited v. KJ Foods CC, Supra, 60. Courts may consider additional factors beyond S-153-7 and business rescue objectives. See O'Brien and Calitz 2021 SAR 409-426 for criticism. Example, a creditor receiving full payment over the contract period while others received accelerated payments. Vote ruled inappropriate. First Rand Bank Limited v. KJ Foods CC, Supra, 60-1. 3. Binding offer. Defined in African Banking Corporation of Botswana Limited v. Kariba Furniture Manufacturers, Proprietary, Limited and others 2015, 5, SA 192, SCA. Offer is binding only on the offerer, who cannot withdraw it. Offeree may accept or reject the offer. Liquidation return standard. Price offered must match what the offeree would get if the company was immediately liquidated. S-153-1B, 2. When an offer is made, the meeting must adjourn for max 5 business days to allow plan revision reflecting the offer. Upon resumption, the same consideration process applies. S-153-4.